May I please ask your lordship? In item number 46 of yesterday's list, my lord, Director Health Services was made party in respect of that COVID victim compensation case, my lord. It was, on my part, it was wrongly suggested, my lord. It should be Director Medical Education. There are 4 directorates, my lord. I am informed, my lord. So I may be allowed to make the correction by way of a slip, my lord, if it is not signed yet, my lord. If order is not yet signed, my lord. If order is not yet signed, my lord, I may be allowed to medical education, my lord.
You can appear for that, Monsoon.
Lordship, I have informed all concerned.
Check it. No, item 4, no, item 1.
May I please, your lordship? Lordship, last occasion, lordship was pleased to. Lordship was pleased to tag the connected writ petitions along with the content matter, my lord. Lordship may come to annexure A of the content petition, page 15, my lord. The order passed in WBC 6187/24, that is page 15, my lord, annexure A. That is item number 2, my lord, wherein the order was passed by this honorable court and that has been violated, my lord. So lordship may come to next page 16, my lord, paragraph 2. The grievance of the petitioner in respect of notice of demand dated 12/11/24 issued by the respondent number 3, whereby an amount of rupees so and so was demanded as an amount towards provident fund payable by the petitioners to the respondent.
Now what happened thereafter?
My lord, thereafter, my lord, we have, after violation of the content, my lord, we have filed a writ petition, my lord, item number 3, challenging the attachment order, my lord. Lordship may kindly see in the affidavit filed by the respondents, my lord, 2 affidavits have been filed. Respondent number 1, my lord, page 52. 62 onwards, my lord. What they have done, my lord?
You are saying about the order of attachment,
Yes, my lord.
page 32 of the writ
So
petition.
let us come to the affidavit. Their affidavit in the content, my lord. Thereafter, I will go.
Now, what is the violation?
Violation, my lord, is page 16, my lord.
I understood there is no order to be passed without the leave of the court.
Yes,
Then
my
what
lord.
happened?
Thereafter, they have page 23, my lord, of the contempt petition, my lord. Page 32, lordship may come to page 32. That is the order of attachment, my lord. They have attached during the pendency of the said writ petition, my lord. Annexure G, my lord. My lord, entire land that is of 1569 bighas of land that has been attached, my lord, for an amount of rupees 1 crore 12 lakhs, wherein around 22 lakhs is disputed, my lord. We have raised our issues that 22 lakhs.
And what do they say in the affidavit?
Yes, my lord. Affidavit, lordship will come to page 52, my lord. See, my lord, how they have a notice of attachment, my lord, issued to the manager, my lord. Now, manager, for manager, they have, I see there is a signature. No notice has been served upon me, my lord. In spite of the fact that, my lord, they say that notice has been served, but for my lord, Asitpur Tea Estate, one person has signed for manager. I have inquired to my client, who is this person? He is not aware of this, who has signed. Therefore, my lord, thereafter, this is the notice of attachment, my lord. Thereafter, next page, my lord. That is the order of attachment, again to the manager, my lord. Again to the manager, there is no reference of case number, no reference of the correction of the 22 lakhs disputed amount, my lord. And that this attachment also not served upon me, my lord. Total area as it on where it is, my lord. Thereafter, my lord, come to 65, my lord. Execution, my lord. Middle portion, my lord, will come.
Page?
Page 65, my lord. page 65, middle portion, my lord. I am not going to the upper portion. We entered the premises of Asitpur at so and handed over the order of attachment of property so to the in charge plantation Sri Robin Gogoi.
Yes,
My lord, he is the hand in gloves.
Hello. See the order 18, it says the department may proceed in the matter, however,
put the
no-
mic in the right position. Yes.
yes, the order, interim order says the department may proceed with the demand notice dated 12/11/24. However, no final order shall be passed. Here, what we have done, if your lordship may see the page 32 again, we have taken only symbolic possession and we are restraining him to transfer. If your lordship sees paragraph
You
2,
could not have done that.
With
we
that
have
my
not-
authorization, my lord.
we have not, he is still running the garden, your lordship.
You could not have done that
This is not,
without
a-
taking the leave of the court. How have you done this?
your lordship, we have not auctioned the garden
Forget about that.
because
First of all, without getting that order vacated, you could not have done that.
here the attachment was only if your lordship says from
Not
transferring
to
a charge.
pass the final order without the leave of the court.
Attachment is not the final order, your lordship. Attached because we have to sell the auction the garden. That's the, of course, that by that time we would have taken permission if we wanted to auction. Till that we have not even issued notice for auction.
I think we initiate contempt against this person concerned. Who is
Lordship,
that person?
for lordship once we will issue apology to that. However, if
No, no, we'll initiate contempt. There's no apology.
if a lordship
You
says
withdraw these orders immediately, forthwith, else we initiate contempt against. It's not that. You can't do this. You should have taken the leave of the
That
court.
I-
You are trying to act smart.
no,
We'll have it on Thursday, Friday. Friday we are having it. We want this orders to be withdrawn. Once you withdraw it, then you take the leave of the court and then we do it.
right. Yeah.
This is not done. The present application has been filed alleging willful and deliberate violation to the order dated 25/11/2024 passed in WPC number 6187/2024, whereby there was a specific direction issued upon the respondents to proceed in the matter in respect of the notice of demand dated 12/11/2024 issued to the petitioner, but no final orders shall be passed without the leave of the court. The said interim order has been extended from time to time. It is, however, very shocking to take note of that without taking the leave of the court, an order of attachment of the immovable property was passed on 31/12/2024, in spite of the respondent having due knowledge of the same. The same appears to be overreaching the orders passed by this court and thereby demeaning the majesty of this court. Demeaning the majesty of this court as well as the rule of law. Mr. R. Sharma, the learned counsel, appearing on behalf of the respondents 1 and 2, submits that the needful will be done. This is the matter on Friday. And in the other petitions, interim order passed earlier shall
Na-
continue till the next day.
Lordship, may I just point out one thing, your lordship.
You
This,
withdraw, then we
this
take-
will, yes, we'll withdraw that.
we are not
Yes.
going to hear you.
He's intending to sell the garden now. He's intending to sell the garden.
You immediately, why are you not filing an IA for vacating that
Yes,
order?
that we'll do on by Friday.
You file an IA for that, for vacating the order, that's a different thing. But without doing this, this is amounts
Yes,
to
I,
demeaning the majesty of the court.
I'll advise, we'll withdraw it. Oblige, your lordship.
May it please your lordships.
Yes.
Your lordships had asked me to check up on a judgment relating to Rule 9 of the SARFAESI Security Interest Rules 2002
Hmm? Hmm.
on the last occasion. Lordship, I tried my best. This is the judgment that I could find. In my humble submission, this judgment is relevant. If your Lordship had already said that the sales certificate has already been issued. So with regard to the sales certificate, there is a judgment relied upon in para 80 of the judgment, page number 2315.
No, madam,
And Lordship will
you
kindly.
have not been able to find out. Let me give
Lord-
it to you.
Lordship.
I, in fact, thought that you would not be able to get it, so therefore
Lordship.
I took the pain of finding it out.
I'm deeply obliged.
18 SCC, Lordship, there is a judgment.
Huh?
2018 judgment, Lordship, there is a judgment.
Which one?
AITC 2018, Lordship, 15 SCC, page 99. That is after even sale, Lordship, giving this sale certificate, the bank has a duty and they can write to the district magistrate, Lordship.
The facts of the judgment which I have just produced, to some extent, the last portion, the final conclusion, para 194 and 195 are very similar to my case. To the extent, Lordship, third-party rights were being attempted to be created in that particular case also and in the present case also. So the Honorable Supreme Court immediately directed that the handing over of the possession of the secured asset to the auction purchaser at the behest of the borrower or anyone else, we will proceed to take the strictest of actions against such person. The court had directed to hand over the possession immediately.
You see, this is the judgment of 2021 11 SCC 537. Now, here is the case. The question is, once the sale certificate has been issued,
Lordship,
the transfer is complete.
Lordship.
It doesn't require even a registration. What is to be done is the sale certificate needs to be only sent to the registry for the purpose of noting it in the books. Nothing more than that. This is the judgment. More particularly at paragraph, we are of the view. Here the case is like this. The aspect of possession by the auction purchaser was already taken care of by our order dated demand recording that the possession was handed over to the auction purchaser in pursuance to the letter, but the backside portion was being used to store goods of the original owner. We have also noticed that in the case of auction purchaser was to continue to enjoy the property and the petitioner defaulted 1 week would granted to remove the so-and-so. Thus, the bank will ensure that those goods are removed within 1 week from the today to facilitate unhindered enjoyment of the possession by the auction purchaser. The learned counsel for the bank agreed that a sales certificate has been further validated and assured that the needful will be done within 2 weeks. However, a submission was made that a sales certificate was then to be handed over to the registering authority for registration and payment of stamp duty. We are of the view that the mandate of law in terms with section 17(2) Roman 12, read with section 89(4) of the Registration Act of 1908, only required the authorized officer of the bank under the SARFAESI Act to hand over the duly validated sales certificate to the auction purchaser with a copy forwarded to the registering authorities to be filled in the book number 1 as per section 89. That's the law. So you don't even require registration.
Not.
One copy has been given to you and the other copy has to be given to the other, to the registry, just for the purpose of entering it
Entering
in
in
the
the
book.
books of records.
Nothing more than that. It is the law. Now you come to, have you seen the Blue Coast judgment? Blue Coast Hotels?
18.
There the question arose as to whether the secured creditor is required to hand over the possession after the sale certificate was over. Because there was a submission being made that once the sale certificate has been over, is given, the duty of the respondent number of the secured creditor is over. And therefore, it was observed that there is no requirement
Authorized officer shall deliver the property.
and or the secured creditor cannot be directed by the court to do the needful. Or for that matter, the secured creditor cannot invoke the provisions of Section 14. This was the case before the
Yes.
Supreme Court. The Supreme Court said no. When a sale certificate has been issued, a limited transfer has already taken place. The remaining transfer is still required to be carried out by the secured creditor by invoking 14 and hand over the possession.
Rule 9(9) as well.
What?
Rule 9(9) in my humble submission, Lordship, the authorized officer shall deliver the property to the purchaser free from encumbrances known to the secured creditor on deposit of money as specified in sub-rule 7 above.
So therefore, the Supreme Court in this judgment, see the judgment 2018-15 SEC 99.
Yes, sir.
Is my learned
Paragraph
friend has just
50,
mentioned
Lordship.
that. Hetu.
Para
50, Lordship.
1.
50.
Uprot. I fail to see how such a finding of manipulation and collusion is sustainable on account of which the risk of this conflict. Intending purchaser cannot lead to an inference of collusion. Oh,
Section 2D 14.
50. This is the finding by the
Para 44. According to the debtor, since Section 14 provides an application for taking possession may be made by the secured creditor, and the creditor having ceased to be a secured creditor after the confirmation of sale in favor of the auction purchaser, was not entitled to maintain the application. Consequently, therefore, the order of the district directing delivery of possession is a void order. This submission found favor in the High Court that held that the creditor having transferred the secured creditor to the so-and-so to the secured creditor and could not apply for possession. The High Court held that the Act does not contemplate taking over the symbolic possession and therefore the creditor could not have transferred the secured asset to the auction purchaser. In any view, since ITC was the purchaser, it could only take recourse to the ordinary law for recovering physical possession. We find nothing in the provisions of that renders taking over the symbolic possession illegal. This is well-known device in law. In fact, this court had also, although in different contexts, held that the delivery of symbolic possession amounts to an interruption of the adverse possession of a party and the period of limitation for application here. The question, however, whether the secured creditor could maintain an application for a possession under Section 14 even though it had taken over the symbolic possession before the sale to the auction depends on whether it remained the secured creditor after having done so. Section so-and-so defines secured creditor to mean a banking company having so-and-so, includes debts and so-and-so. Mullah says all these things, financial assets and all these things. Here it says, we note, we note that even though the entire right title area was were purported to have been transferred, all the right title could not have been said to have been transferred since the possession of them was not transferred to the creditor. The possession was retained by the debtor, who continued to do business and receive rent from the rooms on the property and has in fact continued to do so. There is no doubt that after taking over the possession from the debtor, the creditor also acquired the right to receive the use of the property, that is rent. However, in this case, the creditor did not have the actual possession of the secured asset, but only a constructive or symbolic possession. The transfer of the secured assets by the creditor, therefore, cannot be construed to be a complete transfer as contemplated by Section 8 of the Iman. The creditor, nevertheless, has a right to take actual possession of the secured asset and must therefore be held to be a secured creditor even after the limited transfer area. Thus, the entire interest in the property not having been passed on the creditor in the first place, the creditor in turn could not pass on the entire interest to the so-and-so. Para 56. We accordingly set aside the interim judgment of the High Court and direct the debtor and its agents to hand over the possession of the mortgage property to the auction purchaser within a period of 6 months from the date of this judgment, along with that.
Lordship, in this case also, it has been directed to hand over the possession because only a symbolic possession was there. In the present case in hand before this honorable court also, the bank only has a constructive possession. They have issued the possession notice in the year 2012. In 2016, they have written to the district magistrate.
So here we have to now pass an order to the effect that the question does not set aside. But have you made an alternative prayer in the petition?
Lordship, prayer for this,
What is your relief sought for?
Alternative prayer is not there.
Lordship, may just take your Lordship to page number. My prayer was no doubt, Lordship, with regard to refund, but any other order or orders, that part I have prayed. Page number 23. And the judgment, if I may humbly submit the judgment which I have produced today also, in that case also a third party right was trying to be, being attempted to be created, and the court directed handing over possession of the property to the auction purchasers. The same is the situation in the instant case.
No idea what's all. Sorry.
Here, page 23.
Now, what happened to proceedings are before the section 17 proceedings before the surface?
It's dismissed.
What happened there?
It was dismissed for default.
Dismissed for default.
The order is at page 27. This section 17 application was filed by the person who claims to have entered into an agreement with the mortgager.
That's okay. Now, my question is now, with this relief which you are seeking, can I pass that direction?
Your lordship is well aware, under 226, your lordship has the complete power to mold the relief as per law.
I can mold the relief. There's no quarrel with that proposition. But the thing is, your prayer is completely different from what you are asking. I'm giving you, I'm going to give you.
Contrary, in fact.
Lordship, my prayer was refund, but your lordship on the
You
last.
do one thing. You file an affidavit, short affidavit, to that effect, taking into account their affidavit. You have filed an affidavit,
Lordship.
taking into account the stand that there is a transfer complete with the sale deed. So, just find it.
I
for
had
pass.
filed a response to that particular affidavit actually.
What have you said?
Lordship, it starts at page number 200. The main contention starts at page number 201, para 8.
Now go to the Mandil Lumo. Where are you?
Para 9, we have stated that the respondents did not take any measures to hand over the possession of the property
Well,
to the
that's okay.
petitioners.
This paragraph 11 is there, na?
Yes, Lordship.
I think paragraph 11 will do it. At the time of oxide portrait, the possession is with so-and-so, and as such, the petitioner have agreed to purchase them. In such manner, the player are bound to either hand over the possession of their along with interest or
Yes,
remand.
ups.
I think this will do it.
Lordship.
Lordship.
So we dispose of now.
Lordship.
Heard Miss P. Agarwal.
If
Now
your
click.
Lordship may record Dr. P. Agarwal, Lordship.
Okay, Dr. P. Agarwal, the learned counsel appearing on behalf of the petitioner. You are Mr.
U. Datta,
appearing for
respondent 1 and 2.
One and
either amended memo parties. Mr. So-and-so appears on behalf of the respondent number 1 and 2. Corporation Department and appears on behalf of the Corporation Department on call. The present writ petition has been filed by the petitioner being aggrieved by the inaction on the part of the respondent number 1 and 2. To hand over the possession of the property sold to the petitioner in the auction purchase by sale certificate dated 22/2015. And on the other hand, not refunding the consideration paid for the purchase of the property described in the sales certificate dated 22/2015. The brief facts which led to the filing of the present proceedings are A brief explanation. One Sri Navakumar Das mortgaged a plot of land measuring 2 kathas with one Assam type house standing thereon, covered by Dag number 883 old 2472 new of KP Patta number 41 old oblique 603 new at village Moidan Gaon under Moza Beltola in the district of Kamrup, Assam, to secure a loan amount. The said Nabakumar Das defaulted in making payment, and as such, proceedings were initiated under the Securitization and Reconstruction of Financial Asset and Enforcement of Security Interest Act 2002, for short, the Act of 2002. On 21/11/2012, a possession notice was issued a notice was issued to Sri Nabakumar Das to either liquidate the loan amount within 60 days, failing which the respondent bank would take possession of the mortgaged property. Subsequent thereto, another notice was issued on 4/1/2013 thereby directing the Sri Nabakumar Das for vacating and handing over the said property. Where is the notice, public notice auction?
Notice lordship, it is in the affidavit which they have filed, page number 197.
The records further reveal that the district magistrate, Kamrup Metro, issued an order on 17/1/2013 appointing one Sri Tonkeswar Das, ACS Circle Officer, to take over the possession of the land in question from Sri Nabakumar Das. The physical possession of the said plot of land was handed over to the respondent bank under section 14 of the Act of 2002 on 13/12/2013. and a certificate of physical possession dated 13/12/2013 was issued by the Circle Officer, Dispur Revenue Circle. At this stage, it is relevant to take note of that one Dimbasa Kolita claiming that he had entered into an agreement for sale with Sri Nabakumar Das for purchase of the property, purchase of the 2 kathas of land of the Agote detailed definition is hereinafter referred to the property in question. Relevant to take note of that one Dimbesa Kolita claiming that he had entered into an agreement for sale with Sri Nabakumar Das in respect to purchase of the property, filed a suit being title suit number 553/2013. In the said suit, the said Dimbesa Kolita, where is the injunction order?
Regarding
Where is the injunction order?
2/1/2014, page number 31.
Huh?
Page 31.
In the said suit, the said Dimbesa Kolita filed an injunction application which was registered and numbered as Ms. J case number what is the number? 891. Huh?
1891 of
No, it
2013.
can't be so much.
It appears with that only. Ms. J case number 1891 of 13.
It can't be so long. 891. Ms. case number was registered and numbered as 891/2013. Seeking ad interim temporary injunction restraining the respondent, the said Nabakumar Das, the defendant in the suit, not to alienate and or transfer the suit land to any third person. An injunction order was passed on 2/1/2014, thereby directing the said Nabakumar Das not to alienate and or otherwise transfer the suit land to any third person till the filing of the objection till filing of the objection. It has been informed to this court that the said injunction order, said suit as well as the injunction order, which is more than a decade old, is still pending. Be that as it may, be that as it may, on 30/9/2014, the respondent number 1 bank issued an auction sale notice in respect to the property, fixing the reserve price at 40 lakhs. The petitioner participated in the said auction purchase, auction sale. And on 23/2015, paid the entire consideration of rupees 55 lakhs. A sale certificate was issued prior thereto on 22/2015. Petitioner though was issued the sale certificate, but the possession of the land of the property was not handed over. Madam, tell me one thing, why here I could see somewhere this document. What is this Annexure 6, page 195?
Page 195, Lordship, this is
55
enclosed by
lakhs.
the bank.
Huh?
This has been enclosed by the bank.
But you paid this money prior to that.
Lordship?
You paid the money prior to that.
Lordship, the entire amount was deposited on 27/11/2014.
But why this is 55 lakhs shown as 23/2005?
23/2005.
Kindly come to page 195.
Yes, Lordship, I am at page number 195.
What
Page
does this show?
195 Page 195 is these directions shall remain in force for a period of 6 months from the close of business.
No. You don't have your correct page number. Annexure 6.
Lordship, page 195 has been enclosed, annexure 6 of the writ petition, Lordship.
No, Annexure 6, page 195.
Lordship, in my copy, this is the affidavit which has been filed by the bank. And at page number 195, I have this only. It is annexure number 3, continuation of annexure number 3 to the affidavit, additional affidavit filed by the bank.
You have not been given a copy.
This is that copy.
You have that page 195.
Many it is,
Yes,
it
it is
is,
the same as what I have, Lordship.
is not tally with your lordship's record. In my petition also.
Why don't you correct it with these papers? To argue this matter without correcting it.
Lordship, this was supplied by the
This
council.
cannot be supplied. There has been a correction out here. See page 198.
Page number 198 is the.
Don't say anything. You don't know about this document. Take your seat.
198 Annexure C, lordship.
Annexure 6.
6, yes.
What is this document? 23, 2015. Why 55 lakhs has been shown as paid?
Yes.
If he has paid the amount on 27/11/2014, why it is being shown that this payment was made on 23, 2000 year?
23, 2015.
I think I have an answer to this. The payment which was made by us was in the form of 6 drafts.
What, no, what is this document?
It was credited on, perhaps, lordship, on 23, 2015, lordship. Although she has deposited the draft, it was credited to the account of the bank.
Who?
No, it is statement of account. This is the statement of account of the borrower, lordship. Navakumar Das.
This 55 lakhs was paid to whom? Nobukumar Das.
Lordship, the amount paid by me was credited to the NPA account of Nabakumar Das so that his loan account can be closed.
What is this? I don't understand this amount. This is the bank account of Nobukumar Das,
No.
NPA.
Yes.
Statement of account of so-and-so. P so-and-so to 2016. Nobukumar Das scheme. NPA account. So-and-so. Now, this 55 lakhs was deposited to the loan account of Nobukumar Das.
Yes.
And then also an amount of rupees 18 lakhs remain.
Remain.
Isn't it?
Lordship will
Lordship,
kindly
yes.
see page 178.
Take your seat.
entire
You
statement
don't have
is
the
clear.
papers, Kyle. Take your seat.
6, no? Deponent is,
Payments
11
were made
statement is
on
that the
the
deponent
entire payment of
stated on
55
receipt of
lakhs
the
was
bid
made
amount.
on
The
27/11/2014.
this aid amount was fully appropriate. Yes, it is adjusted to the defaulting account, lordship. Statement is made at
Okay, I understood.
para
Take it.
7, lordship.
Sale certificate was issued on 22/2015. However, on account of the possession of the land, property not being handed over, the petitioner on various occasions requested the respondent bank to hand over the possession. The respondent bank having not handed over the possession, the petitioner filed a suit before the learned court of the civil judge number 1, Kamrup Metro at Kamrup Rural at Gauhati. Are you sure Kamrup Rural?
Lordship, it seems to be a typographical error because the withdrawal I have done from Kamrup Metro.
Kamrup Metro at Gauhati. which was registered and numbered as money suit number 89/2017, seeking refund of the amount of rupees 55 lakhs along with interest at the rate of 18%. Subsequent thereto, the said suit was withdrawn. With liberty to take recourse to appropriate alternative legal remedies. The said prayer was allowed, and thereby the suit was disposed of on withdrawal. The petitioner thereupon approached this court by filing the present writ petition. On 24/1/2023, seeking a direction upon the respondents to refund the entire sum of rupees 55 lakhs to the petitioner along with interest at the rate equivalent to the rate of interest applicable to fixed deposit for the relevant period of time from the date of full payment by the petitioner, that is 20/12/2014, till the amount is refunded to the petitioner. The records reveal that the respondent number 1 and 2 had filed an affidavit in opposition wherein, apart from what has been stated here in above, it is mentioned that the petitioner was handed over the possession of the suit land, of the property, at the time of execution of the sale certificate. And as such, the respondent numbers 1 and 2 cannot be responsible if there is any encroachment in the land in question. It was further mentioned that regarding the execution of the sale deed, the petitioner was repeatedly asked to coordinate with the bank for execution of the sale deed, but the petitioners have not coordinated. At paragraph number 16, it is further mentioned that the respondent numbers 1 and 2 are ready to execute the deed of sale and hand over the possession of the sale of the property to the petitioner within a period of 6 months. The petitioner thereupon filed an affidavit in reply bringing on record various representations submitted by the petitioner for execution of the deed of sale. The respondents have filed an affidavit, additional affidavit, stating inter alia that the affidavit in opposition which was filed earlier was at a time when the title suit number 553/2013 was dismissed for default. But in the meantime, the said suit had been revoked and restored by an order dated 28/5/2024. It is also mentioned that that various attempts have been made for taking over the possession by removal of the livestock. Another additional affidavit was filed by the respondent number 1. On 11th of May 2026, which in the opinion of this court has relevance for the purpose of determination of the present proceedings. In the same affidavit, it was admitted that the petitioner was the successful in the auction sale and the petitioner deposited the amount of rupees 55 lakhs on 2012-2014. It was further mentioned that on receipt of the bid amount, the amount on 2012-2015, the authorized officer of the bank validated a sales certificate to the auction purchaser by stating the undersigned acknowledges the receipt of and in full and handed over the delivery of the scheduled property. The said sales certificate was received by the petitioner on that date. It was categorically mentioned at paragraph number 8 that once the sales certificate had been issued, the title over the land have already the petitioner became the title holders of the property in question. And such sales certificate is exempted from registration under section 17 bracket 2 Roman 8:12 of the Registration Act 1908, read with section 89(4) of the said act. It was further mentioned that the petitioner have therefore to take appropriate action against the unauthorized occupants of the land before the appropriate forum. In addition to that, it is also mentioned that in title suit number 553/2013, an interlocutory application was filed in the year 2024 or impediment of the bank. However, the said application have not yet been disposed of. A reply was filed by the petitioner to the said additional affidavit filed by the respondent number 1 and 2, wherein at paragraph number 11, it is categorically mentioned that in the circumstance, the amount cannot be refunded in view of the title having already been conferred upon the petitioner by virtue of the sale certificate. The petitioner should be handed over the possession of the said land. In the backdrop of the above, this court have duly heard the learned counsels appearing on behalf of the parties, whose submissions were on the basis of their respective pleadings and for the sake of convenience, for the sake of in order to avoid repetition, the same are not repeated hereunder. And for the sake of brevity, this court is not repeating, is not referring to their submissions in the present proceedings. The question which arises in the instant case is as to whether the petitioner is entitled to the refund of the amount of rupees 55 lakhs along with interest, which was the consideration, 55 lakhs, which is the consideration, along with the interest, on the ground that the respondent number 1 and 2 have failed to hand over the possession of the land to the petitioner. Or as to whether any other appropriate directions can be passed in the present proceedings. From the materials on record, it is apparent that in pursuance to the auction sale notice which was issued on 13/9/2014, the petitioner participated in the said proceedings and being successful, the petitioner had deposited the entire consideration of rupees 55 lakhs as on 20/12/2024.
2014.
2011.
2012, 2014, not 20.
2014. Thereupon, a sale certificate was issued on 22/2015. The question arises as to what is the effect of a sale certificate. The sale certificate is being issued in terms with Rule 9(6) of the Security Interest Enforcement Rules 2002, for short, the Rules of 2002. It is well settled principle of law. It is well settled that by virtue of that upon issuance of a sale certificate, a registration accordingly. Title over the land, over the immovable property, stands transferred to the auction purchaser. To the person to whom the sale certificate has been issued. There is also no requirement of execution of any sale deed, any additional sale deed, or even registration of the sale document, sale certificate. This is the mandate of section 17 bracket 2 bracket Roman 12 Roman of the Registration Act 1908 read with. Section 89(4) of the said Act. The only requirement which is to be carried out, the only requirement is that upon execution, upon issuance of the sale certificate in terms with Rule 9(6) of the rules of 2002, a copy of the sale certificate has to, the original sale certificate has to be issued to the auction purchaser, and a copy thereof has to be sent to the sub-register to note it in the books, in book number 1, thereby recording the transfer. This aspect is also the above proposition of law can also be seen from the judgment of the Supreme Court in the case of
It is Lordship B. Arvind Kumar. 2007 5 years. Two 2024 Supreme SC 1100. পাছ কৰি পেলাই জানো দেখুৱাই দিম নাই বিচাৰি পোৱা নাই
The case of HJP Impacts Private Limited versus Assistant General Manager and Authorized Officer Canara Bank, reported in 2021 11 SCC 537. Paragraph 16, paragraph 15 and 16 of the said judgment being relevant is reproduced hereunder. The said proposition of law this court also finds it relevant to take note of another judgment of the Supreme Court in the case of B. Arvind Kumar versus Government of India and others, reported in 2007 5 SCC 745, wherein the Supreme Court observed that when a property is sold by public auction in pursuance of an order of the court and the bid is accepted, the sale is confirmed by the court in favor of the purchaser, the sale becomes absolute and title vests in the purchaser. A sale certificate is issued to the purchaser only when the sale is absolute. The sale certificate is merely the evidence of such title. In the case of State of Punjab and another versus MS Feroz Alloys Forging P Limited and others, reported in Passion Feroz Alloys. Am I yet internet is down like anything? The Supreme Court observed ITC Manipurak Matokde ICT. You're not fit to be here. People is good. Internet doesn't come. The internet is not here. Supreme Court observed that a sale certificate is issued to the purchaser only when the sale becomes absolute. The sale certificate is merely the evidence of such title, and it is well settled that when an auction purchaser derives title on confirmation of sale in his favor, and a sale certificate is issued evidencing such sale and title, no further deed of transfer from the court is contemplated or required. Quoted in oh, but your opponent's not helping us. In the same judgment, the Supreme Court also observed, reiterated, the proposition of law as laid down by the Supreme Court in the case of MS Ejapi Impex Private Limited, Supra. Paragraph 20 of the said judgment, paragraph 18 to 16 to 20 of the said judgment being relevant, is reproduced here in under. Taking into account the above proposition of law, it is therefore clear that with the issuance of the sale certificate, the on 20/2/2015, the property, the title in respect to the property in question stood vested upon the petitioner. In this regard, this court finds it very pertinent to take note of an order passed by the learned coordinate bench of this court, which have been referred to by the learned counsel appearing on behalf of the petitioner. In the case of Ajay Sharma versus Punjab National Bank and two others, report rendered in the case of an order dated 25/2/2021, passed in the case of Ajay Sharma versus Punjab National Bank and two others in WPC number 8227/2019, whereby the learned coordinate bench have directed refund of the amount. In the opinion of this court, with due respect to the learned coordinate bench, the said directions could not have been made without first cancelling the sale certificate. Inasmuch as the title on the basis of the sale certificate have been issued, the title had already vested upon the auction purchaser. In that view of the matter, this court is of the opinion that there cannot be a direction passed, thereby directing the refund of the amount of 55 lakhs to the petitioner, inasmuch as without there being a challenge, without a cancellation to the certificate of sale, the question of refund does not arise. In the backdrop of the above, let this court now take up as to what directions can be passed in the present proceedings. No, the deed of certificate of sale was issued on 22/2015. And it is also mentioned that the possession was handed over. But from the various documents which have been enclosed to the writ petition, more particularly the communication issued by the chief manager of the respondent number 1 to the deputy commissioner, Kamrup Metro, dated 21/7/2016, shows that the possession of the land of the property was not handed over. In other words, what was transferred to the petitioner by the certificate of sale was a limited transfer in respect only to the title without the possession. This court now finds it relevant to take note of Rule 99 of the Rules of 2002. Which mandates that the authorized officer shall deliver the property to the purchaser free from encumbrances known to the secured creditor on deposit of the money as specified in sub Rule 7. In this regard, this court finds it very pertinent to take note of the judgment of the Supreme Court in the case of ITC Limited versus Blue Coast Hotels Limited and others, reported in 2018-15 SEC 99. Wherein an issue arose as to whether the secured creditor can, after the issuance of the certificate of sale, exercise the powers under Section 14 of the Act of 2002. The Supreme Court observed that till the sale may till the possession is not handed over accompanied by the by the certificate of sale, it is a transfer of a limited right of transfer. It is a limited right, a transfer of the limited right. It is a transfer. What is the word used by the Supreme Court? It's a limited.
Limited transfer.
Huh?
Limited transfer.
It is a. It is a limited transfer. And the secured creditor still retains the authority to invoke the provisions of Section 14 of the Act of 2002 to approach the district magistrate for handing over the possession, for taking over the possession of the secured asset. Paragraph number 44, 46, and 48 being relevant are reproduced hereunder. At this, now it is very relevant at this stage to take note of another aspect of the matter for which the respondent number 1 and 2 are not in a position to take over the possession of the land in question. The reason being the pendency of title suit number 553/2013, 13, wherein there is an injunction operating, thereby directing Sri Nobo Kumar Das not to alienate or transfer the said suit property. The said suit is between Dimbeswar Kolita with Nobo Kumar Das. The respondent number 1 and 2 are not parties to the said suit. The certificate of sale which have been issued in favor of the petitioner have not been put to challenge. There is no injunction which is operating against the respondent number 1 and 2. Further to that, the said injunction order which has been passed in the said suit is limited only to Sri Nobo Kumar Das. On the other hand, in the instant case, it is seen that the possession, that the sale which have been carried out, in favor of the petitioner by issuance of the certificate of sale is under the Act of 2002 as well as the rules of 2002. The said injunction under no circumstances would create any embargo upon the respondent number 1 and 2 or even the district commissioner or any other authorities to take possession of the land so that the possession can be handed over to the petitioner. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The issuance of the sale certificate dated 2015 in favor of the petitioner by the authorized officer of the respondent number 1 and 2 amounts to a valid sale of the property in favor of the respondent of the petitioner. The said by issuance of the said certificate, the petitioner would have right as well as the title and interest over the property in question. But the respondent number 1 and 2 is directed to forthwith forward a copy of the said sale certificate to the sub-register Kamrup Metro, so that the sub-register Kamrup Metro shall, in terms with section 89(4) of the Registration Act, note it in the books, book number 1, about the transfer. Number 3. The respondent number 1 and 2 is further directed to take up the matter with the District Commissioner, Kamrup Metro, for taking over the possession over the property. And the District Commissioner, Kamrup Metro, either by himself or through his authorized officer, shall take due steps so in compliance with section 14 of the Act of 2002. The said compliance be Mr. So-and-so appearing on behalf of the petitioner submits, a respondent number 1 and 2 submits that within 15 days, such steps would be taken before the District Commissioner, Kamrup Metro. So it is further observed and directed that in such circumstance, such steps are being taken by the respondent number 1 and 2, the District Commissioner, Kamrup Metro, shall do the needful for taking over the possession and handing it over to the respondent number 1 and 2, so that the same can be handed over to the petitioner. The said period, or the said exercise be completed within a period of 60 days from the date of request made by the respondent number 1 and 2 to the District Commissioner so-and-so. Next. It is made clear that the judge, the order, the pendency of, it made clear that neither the title suit, neither the pendency of the title suit, nor the passing of any injunction order in the said title suit shall come in the way for taking over the possession.
Obliged.
Deeply obliged. Lordship.
Things. Here, section 2, commitments of the bidder and contractor. The bidder contractor commit itself to take all measures necessary to prevent corruption. He commits himself to observe the following principles during his participation in the tender process and during the contract execution. Roman 1, the bidder contractor will not directly or through any other person or firm offer, promise, or give to any of the principal employees involved in the tender process or the execution of the contract, or to any third person any material or immaterial benefit which she is not legally entitled to, in order to obtain in exchange any advantage of any kind whatsoever during the tender process or during the execution of the contract. So this is one of the area where he will have to abide by the principles of the Integrity Pact. And when there is a violation, then section 3, disqualification from tender process and exclusion from future contract, section 3. If the bidder contractor has committed a transgression through a violation of section 2, such as to put his reliability or credibility into question, the principal is entitled also to exclude the bidder from future contracts and award processes. The imposition and duration of the exclusion will be determined by the severity of the transgression.
Mr. Advocate General, oh, you are now
Senior advocate.
senior. Tell me one thing. Yeah, the issue is on those. Yes, it is a violation of this. You can very well terminate him, as well as also you can debar him for future contracts. No problem.
Right.
But can you do only on the basis of a case being pending?
Yes,
To me that.
yes. Check the page 39. Lordship will kindly see the banning policy at page 34. It starts.
Yes.
This is the banning policy of Oil India Limited, and clause 4 and 5 are the relevant portion. Page 36, Lordship will kindly come.
Each.
Page 36. Provisions for action in case of erring, defaulting agencies. An agency can be considered for debarment if it is determined, Lordship will kindly mark this word determined, that the bidder has breached the code of integrity, which I have just shown, section 2, as per rule 175 of the General Financial Rules of 2017. Then 4.1.1, Code of Integrity as contained in Rule 175 of the GFR and OM dated 2/11/2021 of Department of Expenditure, Ministry of Finance is reproduced as under: no official of an agency shall act in contravention of the codes, which includes prohibition of making offer, solicitation, or acceptance of the bribe, reward or gift, or any material benefit, either directly or indirectly, in exchange for an unfair advantage in the procurement process or otherwise influence the procurement process. Now coming to page 39. 5. Action against erring, defaulting agencies in respect of an ongoing tender contract where the agency has erred, defaulted. 5.1, action against the agency in respect of an ongoing contract, tender contract where the agency has erred, defaulted any of the provisions as mentioned in para 4.1, which I have just placed. Now coming to Roman 2. One is irregularities are prima facie established during evaluation of bids, that I am skipping for the time being. Roman 2. The irregularities are prima facie established after award of the contract. So I have to be prima facie satisfied. That means the trial or the continuation of the criminal investigation or criminal trial is not material. What is material is that the authority has to be prima facie satisfied that there has been a breach. During execution of contract, if the contractor is found to have erred, defaulted any of the provisions mentioned above in para 4.1 and 4.2 in respect of ongoing contract, such contractors shall be put on banning debarment list of Oil India after following due process. The process we have followed. Only
The
thing
due
is that
process, what is the due process is the third paragraph. After following the due process, the order of AI is so and so. What is the due process to be concluded?
due process, that notice, then hearing, personal hearing,
No,
giving the,
have been committed shall be terminated.
which we have done.
Understood all these things, but where is
Now,
your,
first there are two parts. One is if there is a procedural lapse, or whether we have acted beyond our capacity. That what the query coming from the court is that whether pendency of a criminal trial can be a basis to debar him or to bring him under the banning policy. Is if I'm not wrong, if that is the core question.
Mr. Sekar, let us come to another much simpler. I think the formulation out here of this case can be made on similar to a departmental proceedings. Now, in a departmental proceedings, you can terminate, suspend and terminate.
Right.
Pending a criminal trial, it can happen. There's no
Yes.
quarrel with that proposition. But then also in a departmental proceedings, at the time of termination, you come to an opinion that yes, insofar as the limited, it is not beyond, you see, for criminal trial, it is a beyond reasonable doubt.
Right.
But on preponderance of probabilities, you come to a finality that look here, from what we have, as per us, we think that this is a case which is made out, and as such, we terminate him. He is defaulted on these accounts of misconduct, for we terminate him. Therefore, that termination will happen, which is different from a conviction. A conviction may happen in a criminal case for which another proceedings may happen. Even a person who is not, who has been otherwise given a goodbye, the departmental proceedings has also been done with, and nothing has
Parallelly,
happened. Then
both can
also in
run
the criminal
both on different
proceedings, if it happens,
parameters.
his he can be terminated. These are things. But here, mainly because of the fact that there is a case pending.
That is not the
Unless-
case. That is not the core issue. What he has done, he has given bribe to our person, our officer.
So the way you're finding,
That is, I'm coming to that. I am first saying, placing the law and the facts. I can go reverse also. But what we have to establish is that to take that particular penal action, then we must be prima facie satisfied. Now, whether our decision-making authorities has applied their mind or they have acted mechanically, and they have to be not following the principles which is based on any criminal trial, that beyond reasonable doubt. That is not our principle. We have to adopt the principle of preponderance of probability and prima facie at first look, first impression, whether a case is built up or not, to take a penal action against
and
them.
there has to be a determination.
Exactly, Lordship. That determination also I am coming. So what is paramount important is that the authority must be prima facie satisfied.
That he has committed this.
He has committed this. So that is why I have placed page 39, 5.1. Roman 2. That prima facie is the core word which is inserted in the banning policy. Now that decision-making process. That is the impugned order, one of the impugned order, page 394. How this committee gave the final recommendation. Page 3, it is 8/10/2025. Have Lordship got it this page now, Annexer R12, 394. So the preamble that is regarding all the procedures which we have followed. 1.4, in view of the serious nature of the allegations and the involvement of oil personnel, our own person, the matter was deliberated in the LMC meeting held on 10/6/2025, and after discussion, LMC opined as under to suspend delivery of materials against order dated 3/3/2025 for supply, installation, and commissioning of truck-mounted wireless winches, etc. 2, to initiate action for suspension of United Drilling Tools Limited as per oil's banning policy. The process started. To allow MS United Drilling to supply lines casing number so-and-so with crossover against order dated so-and-so, considering operational requirement of the item. To continue procurement of proprietary items from United.
Let's come to number 3,
I am coming there, Lordship.
398.
I am going serially, but if Lordship wants to straightway go to 3, then the observations. I have gone through these observations. So now, how the prima facie determination is done. The language may not be very accurate, but the overall emphasis is taken on the materials placed before the committee. Observations. The banning committee, after examining the facts of the case, so there is an examination. The provisions of the banning policy of Oil India Limited, revised dated so-and-so, and the submission made by the concerned vendors, white letter dated 13/8, places on record the following. Committee noted that the order dated 3/3/2025 for supply, installation, and commissioning of truck-mounted wireline winches, which involved both suspected oil officials named in the FIR and MS United Drilling UDT, had signed the integrity pact in this case. However, it is observed that the FIR does not mention any specific tender, purchase order, or contract. In the absence of such particulars, it is not feasible to undertake any order or tender specific examination to identify a potential breach of integrity. The CBI is currently investigating the matter in reference case number so-and-so. The FIR named both oil official and representative of UDTL in connection with bribery and corruption. This directly contravenes. This is one area, Lordship, one word. This directly contravenes. After taking these materials, the decision, first decision, opinion of the recommending committee is that this directly contravenes section 2.1.1 of the Integrity Pact signed by the vendor, which prohibits bribery, inducement, or collusion of any kind. And it calls for initiating action for putting them on holiday, debarment, as per clause so-and-so of the oil banning policy 2023. Further, clause 4.3 empowers the company to place a vendor under suspension upon receipt of the communication from vigilance or investigating authorities. As per SOCO's reply dated so-and-so, United Drillings, it is stated that the case is under investigation and so far as no judicial order has been passed convicting the company or any of the officials of United so-and-so as referred in Rule 151, Debarment of Bidders of General Financial Rules issued by the Government of India, revision so-and-so. Moreover, as per clause 9.0 of Oil Banning Policy, Rule 151 of GFR 2017, is applicable for debarment across all ministries, department, whereas the banning proceedings in current case has been initiated for banning the party from oil only. Further, the committee noted that, Lordship, they have taken into consideration. The committee noted that as per GFR Rule 175(2), the procuring entity, after giving a reasonable opportunity of being heard, comes to the conclusion that the bidder or prospective bidder, as the case may be, has contravened the code of integrity, may take appropriate measures. The UDTL was given an ample reasonable opportunity to defend, place their case, including the opportunity for personal hearing, which they could not avail by not submitting their final so-called reply by time. The time is fixed by this Honorable Court, 7 days. While Rule 151 of the GFR stipulates debarment upon conviction across all ministries, department as per oil banning policy, Rule 175 empowers the procuring entity to take appropriate measures where a breach of code of integrity is prima facie established. So that CBI investigation, arrest, suspension, all these things, prima facie establishment, something is not right. This gives oil the authority to act before conclusion of the trial in order to safeguard its interest. The committee observed that based on available information, no conclusive evidence or conviction has been established to date. Oil banning policy does not contain specific provisions for cases under investigation by government agencies or those they are sub judice. However, the FIR lodged by CBI accusing officials of oil and MS United Drilling is not merely an allegation but a formal investigative steps which constitutes strong prima facie evidence of violation of section 2.1. Roman 1 of the integrity, that is giving bribe. The committee further noted from the aforesaid FIR that has now been registered as criminal case number so-and-so in anti-corruption CBI Ghaziabad, wherein the court by order dated 14/8/2025 has taken the cognizance of the offense under section 61(2) of the Bharatiya Nyaya Sanhita and section 7, 8, 10, and 12 of the Prevention of Corruption Act 1988 against the accused persons named in the charge sheet, including companies MS Drill. So charge sheet is also there, not only FIR. So one step further after investigation, that means a prima facie case has been registered, charge sheet has been filed, and the court has taken cognizance of that charge sheet. So prima facie, we are on the right track. Had it been the final opinion, then during the investigation and during the trial, no scope will get by any of the authorities to take any action to prevent that.
My question is, why
I'm going further a little.
No, we understood. All these things are understood. But my question is, you can on preponderance of probability come to an opinion. Forget about the trial.
Yes.
You can very well come to an opinion that look here, this has happened, and therefore we are doing whatever.
That is
preponderance
precisely
of-
we are doing, Lordship.
Understood. But can you just say that because of the FIR being filed or an cognizance is taken?
No, Lordship, it is not.
Where is your
It is not.
independent application of mine regarding that this has happened?
That is why these lines are important. May not be very correctly or like a judgment is delivered by reasons. Here, what is that? This first line at the top, this directly contravenes section 2.1.1. That means the authority has applied his mind. After due application of mind, it is not a mechanical exercise. That there is a FIR, there is an allegation, and therefore there is a violation of 2.1.1. That means giving bribe. Then the pendency of the cases. Then this strong prima facie evidence. And our banning policy very categorically says that if you are satisfied prima facie, then you can initiate the action. Going further, Lordship. The committee further noted that United Drilling has challenged the so-called notice come later of suspension notice of oil before the Honorable Gauhati High Court contending that the so-called notice violates principle of natural justice since the investigation is still pending adjudication. Importantly, the court by order dated so-and-so has not granted any interim relief, which implies that the suspension and proposed actions are consistent with natural justice and clause 4.3 of the banning policy. Committee further noted that given the seriousness of the allegations, the committee does not find merit in closing the proceedings against the vendor and continuing business with a vendor facing criminal trial of bribery, corruption, poses significant reputational, operational, and compliance risk for oil. If the vendor is eventually convicted, oil's credibility and decision-making integrity would be called into question for continuing its association. Para 8.0 of the banning policy stipulates that the process and decision regarding debarment should ordinarily be complied within 4 months from the date of constitution of the committee. Further, as per clause 7.0 of the banning policy, duration of the debarment shall not exceed 2 years, including suspension period. However, corruption-related judicial proceedings such as the present CBI investigation, now it is trial, typically extends well beyond the time frame. Therefore, if oil were compelled to revoke a ban merely due to expiry of this period, while the investigation or trial is still going on, it would defeat the core objective of ensuring ethical dealings. The committee therefore considered it prudent to recommend that the vendor be banned till the conclusion of the judicial proceeding, even if this extends beyond the 2-year ceiling, in order to safeguard oil's integrity, reputation, and operations. However, the committee also observes that banning policy does not explicitly address cases where judicial proceedings remain pending. Accordingly, in these exceptional circumstances, the committee recommends that management exercise its discretion to impose and sustain the ban until conclusion of judicial proceedings. A recommendation, the banning policy therefore proposes as under, so it is for 2 years. But they have considered everything.
Now,
Now-
Mr. Saika, general, I'm putting a question. One of your officers is caught in corruption. Where's the criminal proceedings? How will you deal with him? in the department? You suspend him immediately upon his
There are
arrest?
2 parts. One is the criminal. In criminal case, he may get a acquittal also. That will not deter the authorities, the department, to remove him from service or give any penalty.
All
These are 2 parallel.
all understood. My therefore questioning, what are you going to do in respect to that person?
Which proceeding, Lord?
In
The criminal.
departmentally? Departmentally, what are you going to do?
Departmental will continue and will close it.
Understood. So you close it.
Close it, I mean, close
You
it
don't
means-
close it on the basis that the criminal proceedings have been cognizant
That-
sanction has been
we-
granted.
We never do that. We take a independent course and we come to a
Absolutely.
logical conclusion.
So do that.
Yeah,
Yeah, do
we have
that.
done it. We have
No,
done-
you have not. You do that. My question is that you do that and finish
No,
it
no,
off.
we have-
Mr. Saikya, I am not in favor of the petitioners in that regard that this, because there has to be a line taken out. Somewhere down the line, if one has to say that once it is only upon conviction there can be a debarment, it will have far-reaching consequences on the very power of debarment.
Exactly. Lord.
So therefore, there has to be something done prior to that, because the conviction may take 12 years, 15 years. I am thinking of the MP MLA where in spite of the Supreme Court directing, 22 years, 23 years has become a normal guideline.
Other UAPA cases.
Yes. So it has become a normal guideline.
20
So
years,
therefore,
18 years, Sanjay Dutt's case,
Ah.
92, and final conviction in 2018.
it cannot be
But
there.
in the interim, the banning policy has given this scope.
So banning policy is drawn from 175. Now, if we see 175, see 170, 151 says convicted. But 175 says, kindly see page 51.
Code of integrity, 175, Lordship. 150?
Because this is the power you are exercising, 175.
No official of a procuring entity or bidder shall act in contravention of the codes which include prohibition.
This is one to all these things. Disclosure. of conflict of
The
interest.
procurement after giving reasonable of being heard comes to the conclusion that the bidder or prospective
Yes.
bidder, as the case may be.
So why
Yes.
don't you come to the conclusion on your own? On your own. My question is that, have a conclusion on your own. Once
No,
you have that
that,
conclusion.
that liberty Lordship may always give us, or otherwise also on our own also we can do. But whatever we have done till now, that the banning policy says that debarment can be for 2 years. Recommending authority also said that it should be till completion of the trial. That is also there, but in spite of that, it has been given as per the banning policy only 2 years. So we may take a call after 2 years. What to do?
Huh?
Till 2 years, he is no more in the scenario, except supplying certain things, because he is an OAME also. So he's,
So therefore, what you need to do is come to conclusion on your own.
no,
Once you come to the
now the
conclusion,
court
there's
issue
nothing
before
else.
this court is, I fully agree, Lordship, we will take a final call also if required. But the thing is that whether the materials before this honorable court, whether we have violated anything,
You have not violated natural justice, no quarrel with that.
Lordship.
But without going to the
And
conclusion-
whether we have gone beyond the action which can be taken under the banning policy or the
No, one thing
Read
is-
with
listen,
Integrity Pact.
for being prima facie satisfied also,
We have
you can be, there's no quarrel, but it has to be independent of the filing of the case.
that is why, Lordship.
Because the moment you are doing it on the basis of an FIR,
No,
because you
Lordship,
see,
it is not, you have, Lordship will have to see
Yes.
that we have
show
also
me
taken
one
into
letter that
consideration.
irrespective of that, you have come to a conclusion that he has committed this. Prima facie. Word is there,
One
prima facie he has
definitely.
committed that.
One part is that our own officer, we have suspended him, DP has been drawn.
He has been reinstated. and-
Reinstated, that the reinstated is not a clean sheet. It is not a clean sheet. So he is,
Determination is in favor, prima facie.
yes,
Apology, sorry.
yes, let me hear the comment, then I will come. No, it's okay. So Lordship, I leave it to this honorable court. Whatever is permissible
No,
under
my
the
only
existing,
worry- No, Mr. Secretary, this is a worry not only in this case. This is, okay, this is one case which can, is again another worry. Because what is to be done? Because there are certain judgments of the Supreme Court wherein says that while criminal trials are there, because in one of the matters, there was a, when I was taking up that APSC matter, one of the submissions was made that we give up that particular prayer for that stay of the proceedings pending criminal trial. That was the prayer which was given up. Then thereupon, on the basis of that, I drew up the judgment and delivered. Then division bench, it has gone. Yesterday, they was making a review application for that this needs to be removed. This is an important aspect. Now, whether if I permit you, because if I interfere with this and permit you to carry out, would it lead to a circumstance later on that, look here, the criminal proceedings are there. And if there is there, they cannot arrive at or they cannot ask us anything on the defense. That might be also question.
that will be the next question. They will come to the court when we start that exercise.
Yes,
They will
that
say that
is-
I will not disclose my defense now.
That is the only thing which I am worrying. That is why I am saying, asking you that what is to be done. Therefore, I said Advocate General. Then in the meantime.
Inappropriate case, but
Yeah.
here I will not make any comments. My comment is very clear,
No,
Lordship.
not in that
That
case,
whatever
but
we
I am
have done
saying that
as
how
per
to
the
take care of
integrity
that?
pact, as per the banning policy. We are not violating any of the provisions, be it procedural or otherwise. In application of mine, judicial application of mine, of that committee, they have considered which are most relevant. One part is definitely sure that FIR as well as a search sheet and taking
I
cognizance
saw
by the court.
another document. This is a very interesting document, which last time they had shown it to me. Somebody has some minutes have been recorded. Where is that? You showed me the
I think
minutes, no? They say that
No,
we
the
cannot
committee report,
continue-
which
Huh?
the Learned Advocate General is reading, the committee report.
The committee's report that we don't want to do business with this type of people.
No, that is
Here only. We
395.
have,
yes, Your Lordship.
in the,
Reputational loss.
Age?
no, we have to do because
Lordship, I
page
think
395, that Lordship will
3.5.
find.
399, 3.5 is what Lordship is poses significant reputational, operational compliance risk for oil.
No, we don't like to do the business. This is some word you mentioned last time. Some minutes were there.
Lordship, I had placed this committee report.
My only worry, Mr. Saikya, is that if I remand it, then if they take that excuse, then how do you tackle that?
They will take the plea that let the trial court be over, and for next 3-4 years, it will be a status quo. That means they will continue business with Oil India.
So that is the only worry I'm having.
Otherwise, in my humble submission, there is absolutely no infirmity, no illegality in the impugn orders.
But Mr. Saikya, this court cannot also close eyes on what has been written to the effect that your emphasis is on the FIR and the cognizance taken.
Only that.
No, FIR, then it has, the much water has flown thereafter. FIR led to a charge sheet, and charge sheet led to a taking cognizance by the court. The trial court could have rejected the FIR, charge sheet, I'm sorry. And they have accepted it also. Not the FIR, neither the charge sheet has been put to challenge before any forum. That means they are happy and they have accepted the charge sheet.
I've got it, the impugn, page 404. FIR lodged by CBI accusing officials of oil and so constitutes the prima facie evidence of violation of section so and so. The said FIR now has been registered as so and so, wherein the court so and so, so and so, so and so. Rules 175 empowers the body here. Continuing business with a vendor facing a criminal trial of bribery poses significant reputational, operational, and compliance risk for oil.
Lord,
My only question is this. Now, where do I find that? That if a criminal trial is going on, it will lead to debarment. Show me that.
a criminal trial, there is no specific word,
No, no,
but
this is-
prima facie satisfaction is there.
Kindly see 404. What is the base? 404, the fourth new,
Lordship.
This is the impugned banning order.
huh?
This is the impugned banning order.
The continuing business with a vendor company facing criminal trial of so and so poses significant reputational, operational, and compliance risk of oil. This is the only reason which is seen.
This is echoing the committee.
That is
I
the-
only worry, you said, you give me a good answer to that point.
No, I leave everything. Whatever is there, I cannot improve the facts.
I'm
The
not on
facts are
that.
before this honorable
Give me
court.
an
Only the
answer-
interpretation can differ.
No, give an answer to me. If I interfere and direct you to do it, how do I stop there? Not to raise that issue.
And that is why, Lordship, that 2 years period, they are out. Now
2
already,
years is given because of there is another provision in the ZFR.
No, on the basis of
ZFR
the
provides
banning
a
policy
provision.
also.
Yes, there is a ZFR.
Banning policy.
provision.
policy itself.
The banning policy and of the ZFR categorically mentions that. Where is that? Normally it should be 2 years and or it is in except circumstances 5 years. Where is that? Is the policy enough? Yeah.
Actually, not more than 2 years.
Kindly come to 151. In a case of conviction also, a bidder debarred under subsection 1 or a successful shall not be eligible to participate or procurement demand for a period not exceeding 3 years, commencing from the date of debarment, and will maintain such list with the procure entity may debar. So this is in a case of conviction, it is 3 years.
Lordship, page 42 is in the banning policy.
Huh?
Page 42 of the banning policy also says that 2 years. Not exceed 2 years, 6
page
months.
49, Roman 3, 151 Roman 3, Lordship will kindly
Mhm.
see.
Page
Page 49, debarment from bidding rule 151, sub rule 3.
a debar or iman for a period not exceeding iman if determines the bidder had breached the code of and will maintain such list will be paid in the year. No, therefore,
A procuring entity may debar a bidder or its successor from participating in any procurement process undertaken for a period not exceeding 2 years.
Understood. So therefore, this is in a case of conviction.
151.
So if there is a
Yes.
conviction which leads to
Yes,
a
Lordship.
finding that yes, he was in violation.
That is a
of AR
conviction.
3.
That is fine, Lordship. Now, in our case, that situation has not arisen.
No.
In that situation, what is provided is under the banning policy. So that is for in case
Would
if
you take the plea of pendency of the trial?
Lordship,
If I interfere out here, would you take the plea of the pendency of the trial?
this this commitment will not help,
Yeah.
Lordship, later on.
whatever law permits,
Ah,
we shall.
then why
avail.
should we? There's no
Lordship,
delay. How
may I
many years-
just, may I just attempt, Lordship is concerned
then how
about
many years are left?
one more year.
One more year.
Let us
Exactly.
wait it pending, like the public prosecutor matter. Without that commitment is very difficult.
Lordship,
No,
may I,
even
may-
if commitment is
may-
given, Lordship,
Huh?
that will not
council's commitment will not.
not help. Even if
It's
it
unfair.
also,
I cannot,
then they will say under duress we have done it.
yes. They'll file cancelling my license.
No, no, I'm
But
not.
prima
asking-
facie, we are
Only
satisfied.
asking you to obtain instructions.
No, Lordship, may I just attempt?
I'm not asking
yes,
you to give that.
Yes, Your Lordship. May I just attempt an interpretation on the banning policy? Lordship is in kind of.
I'm satisfied with your case.
No, no,
There's
Lordship,
quarrel
no,
with
no,
that.
Lordship.
My only worry is this: the moment I interfere and ask them to do it, and I have allowed them to have an independent ear, then would you raise the plea of a defense that there is a trial pending? You take that.
But
defense,
Lordship,
then
under the
unless
exist,
I can very well pass an order to that effect.
Yes, we
also,
can
that
take
that
is-
Lordship can always direct, no
we
issues.
can very well
Absolutely
say
no,
to the
no.
lawyer,
2 o'clock, I'll take instructions. Lordship, may I just 5 minutes, the scheme of the banning policy.
Understood,
No,
madam.
Lordship,
Madam, the
no, Lordship, he
solution-
has relied on Lordship, the prima facie,
I-
Advocate
I-
General says
why-
prima facie.
Why are you
Prima
trying to
facie
make
is-
your submission when I'm in your favor?
Lordship,
In this point,
Lordship
but
is-
I'm not in your favor in the other.
no, Lordship is then not accepting the thing that prima facie alone is sufficient?
So the prima facie also has to be independent, fine, prima facie.
No, Lordship, prima facie is not conclusion. Prima facie and conclusion are two different stages.
Even if it is. a
Lordship,
prima
because
facie
the
also,
banning,
even if it is there might be the reason why they have used the word prima facie is the reason.
Lordship, in the banning,
Because
are very clear. May I
tomorrow-
just take 2 minutes?
No, there is a reason why they have used the word prima facie. Tomorrow, because of that, they can very well take the plea out there that it is a prima facie, yeah, so therefore it would not lead to a conviction.
Lordship, my only submission is on an interpretation of the banning, the only place, 2 places they use prima facie. One relied on by the learned Advocate General, 5 Roman clause 2, where if in a prima facie, you can reject the bid. The other is for suspension. On prima facie, you can suspend for 6 months. Everywhere else, where there is a banning, because banning transcends this contract and takes you to every other contract, it kind of is a civil death for my business. It says there must be a determination stroke conclusion of contravention. So prima facie, the banning guidelines are very, very clear. For suspension, they say prima facie. For rejection of my bid and terminate my bid, they say prima facie first rejecting and then they say conclusion. But for banning, they're very, very clear. They say go to 175(2), conclusion of contravention. 4.1, determination of contravention. So prima facie is not, there has to be a determination of, as long as the Lordship accepts that there must be a determination of contravention.
I'm in your favor.
And the other thing, Lordship said I should not raise it if your Lordship is in my favor, but I will just make a point. If they have reinstated the main actor of the crime, then there must be a prima facie determination of non-guilt on him. I asked that question. On what basis? According to them, posturing, this whole thing is giving a reputational, operational.
There might be you see, the rules may very well say that a person cannot be kept suspended for a long time. So for that, he may be reinstated. pending criminal trial out there, he may be reinstated, because criminal trial is another thing. You are keeping a lien, the moment you are keeping him under suspension, you are paying him 75% without any work. He's happily moving around everywhere. So therefore, that must be the reason why. So therefore, my question, for reinstatement of that particular person, yes, whatever may be, he has been reinstated. We find a lot of people out here. I find many cases where they were behind the bars for a long time, and after his conviction being set aside by the High Court, he's now asking for filing petition for reinstatement from suspension.
To somebody who says I'm
Case which
zero
had made
policy, they should have a
headlines
policy.
One day, a case which had become headlines, now he's asking for reinstatement. So these are things which are there. That is a different thing on a service matter. My question is, whatever may be, there has to be an independent decision, the horse, the filing of the FIR or cognizance taken. Yes, very materials on the basis of which cognizance taken, they can form an opinion
Yes.
and dwell in it on their own words. That is enough for them. But only worry is, this is how it is. But I think we can take care of it by passing an order to that effect, that under those circumstances, if we pass an order that this finding would have no bearing on.
Yes, yes, Lordship.
Give you the time, and they will remain suspended till then.
Yes.
That is the thing.
We
I'm
take
not,
instructions
it
at
will
2
go to
o'clock,
the
we come
back
back.
to the stage of suspension. Not
No
to the
difficulty.
temporary. So you do it.
You'll
The Lordship
continue
will,
suspension till, you'll not set aside this banning. Lordship is
I'm
inclined,
setting aside the blacklisting, but it will remain as suspended. Or if they don't do it within 60
I think
days,
the powers of suspension is only 6 months,
I
Your
am,
Lordship.
whatever this honorable court says, will follow the direction.
within 60 days, they will complete it.
Yes, 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 yes. Lordship, I'm relying on the judgment for whatever it's worth.
What judgment?
Jurisdictional fact. That is my whole case.
What jurisdictional?
The determination and conclusion is the jurisdictional fact. An authority which exercises without that, a certiorari lies. One paragraph.
Then I'm already passing an order. Again, need something.
Lordship may record.
Yes, where?
Paragraph 74.
How does this have any relevance?
Lordship, I'm saying clause 4.1, clause this thing, there has to be, and 175.2 requires a determination of contravention. That is the jurisdictional fact. And short of that, they could not have exercised the clause. That is my submission.
So therefore, here the
Yes.
simple question is, they are referring, they are deciding that they decided on something, a material without coming to a conclusion.
Correct. Lordship, that is it.
How
So
is
there,
this judgment relevant?
Lordship, because the jurisdictional fact of 4 and 175.2 is determination and conclusion.
So therefore,
If you
they are
don't
not
do that-
determined. If they are
Lordship?
not determined, obviously,
So therefore, they've erred in exercising their powers to ban. If your Lordship is satisfied without the judgment,
don't need it.
Lordship, then we don't need to get instructions. Your Lordship will say pendency will not.
You take your own risk, because if you say to that effect, that's the reason why I put it under suspension and directing them to complete it within 60 days. Now, if on account of you, there is a delay, because don't take this decision in view of that, you know what will happen, it will remain under suspension.
Lordship,
I think that is a fair.
Lordship,
Catch 22 situation. Catch 22 situation.
Lordship, most likely, I think law will not permit me to take pendency as a ground. If they.
You never know. The ingenious ideas of the lawyers, you never know.
and the judges, because there has to be a judgment, your lordship. Lawyers saying will not help unless it's translated into a judgment. So lordship, our instructions are we will not take.
No, it's okay. I'm not putting it. But therefore, as you will be put under suspension, kept under, set aside and put you under suspension, directing them to complete it. As to whether the exercise of jurisdiction has to be based upon a determination to the effect as to whether there is a violation.
But my submission, Lordship, may kindly record that.
Definitely.
We have already determined. That is my submission. May
And which
Lordship
I
may-
am rejecting it, that it cannot be on the basis of these two.
May
You
advise
can to do it
and cognizance.
independently of whatever material you have, you do it. You may, I'm not here to advise, but you may
No, no,
incorporate
I fully agree, but my recording may be there. That
Obviously,
yeah.
your
Lordship may
submission will be
reject it, but
recorded. Don't worry,
submission
I'll
that
record it.
our committee has taken into all relevant.
I'll pass the
material.
order today itself, but not now.
Lordship.
Pass the order
I'll
because
be more
if I
happy.
pass an order out here, long judgment, you can't keep the Advocate General there for a long
no.
time.
He may
So-
be excused, your lordship.
No, it's okay. Lordship may be
Hey, you take
comfortable.
judgment today. I'll deliver it. Don't worry.
Obliged, your lordship.
Highly obliged.
It will be shown as disposed to dates.
Deeply obliged.
Yes, madam. Just ask them to put the page number and give it to me. The relevant page numbers which you have referred to.
Yes,
Just give
yes,
it to me.
yes.
Yes, please this. Oh yes, Mr. Saikya, what is this?
Yeah, I have filed the affidavit bringing the record that the petitioner was a riot and they have also admitted only that I have brought the Dhammabundi,
You have filed an affidavit
my lord,
in reply.
affidavit in reply.
Madam, you obtain instructions in
Mal-
this thing,
mal-
because what they are saying is that these particular persons whom you have paid the compensation,
Malam.
his name has already been struck off and the petitioner's name has been brought in
Yes, in 75.
1975. He has brought on record that document.
Malam.
The affidavit has been filed on an affidavit in reply has been filed on 17/8/2026, wherein certain new facts have been brought onto light. Considering the above, this court finds it pertinent to provide the state an opportunity to obtain instructions and, if so necessary, file a reply thereagainst. So list this matter again on 25th of September 2026. The reply, if any, the instructions and or reply, if any, has to be brought on record on or before 24th of September.
Madam.
Mr. Nath, here he has brought in certain aspects by way of an additional affidavit in reply. I'm giving you an opportunity to go through it, obtain your instructions. Because here what has happened, the payment has been made to another person whose name, as per the Mr. Saikya, was struck off in the year 1975 and the petitioner's name was inserted. So this is a new fact which comes into light. So I think you need to obtain instructions. I'm fixing it on 25th, so on 24th. And 24th, either you file your reply or you get your instructions. Chalo. Mr. Doctor, you just wait for some time. There's one matter which I couldn't deliver the judgment yesterday. Let me finish it off. Of Mr. Adas. Yesterday it reached at 5 o'clock. I couldn't finish. 2 minutes.
May I please, your lordships? My lord, They say,
You have nothing to argue, I have to.
no, my lord, I
Okay.
want, I want the real fact, my lord. My lord, Nogan Kakuti, father of Bishojit Kakuti, and Miranam Kakuti is cousin brother, my lord. Huh? Cousin brother. Cousin brother. Son of Kukuiram Kakuti. Original. Huh? The land divided into 1 bigger 10 lessons should be half portion. Except one side Miranam Kakuti and one side Nogan Kakuti.
Mr. Das, I'm dismissing your petition. You now need to go to the civil court. Okay?
My lord,
No more.
I want to add one submission.
No more. Your
Well,
submission-
give me
your
direction.
submissions are-
I am hopeless, my lord. I am hopeless. My lord, I am hopeless, my lord. Because my portion of land is sold, my lord.
By?
Huh?
By?
My forgery, my lord.
Who? Who has sold it?
My lord, kindly see, Annex 12, my lord.
Who has sold it?
Huh? Sold, purchased by sold Bishojit Kakuti, son of Nogan Kakuti, and Miranam Kakuti, the father of Biran Salai, Biran Kakuti, or cousin brother, my lord. Half portion of land. It is in the interest of us, my lord. My lord,
Has
kindly
it
see,
sold by whom?
my lord, their land is kindly see on last occasion, on last day. He says that does not understand. How can the mutation is cancelled? Mutation is cancelled. It may be give me a person, implicit circle officer. The complaint, petition, miss case, file before the circle officer, Kamalpur, my lord. Then their mutation case. I kindly see page 60, my lord. Page 16, my lord. I am hopeless, my lord. My portion of land is forgery sold. Sold. My lord, kindly annex 12, my lord. Forgery, my lord. Some dalal, brokers. The name mentioned in the paper also. Published in paper also, my lord. Their land is sold at water value, my lord. পানির দরদ বিক্রি করেছে।
You should go to the civil court.
It is, give me direction. My lord, my lord, responded authorities. Part responded 3. They do not sell the land. They should purchase the land after proper vacation.
Who should purchase?
AGACL.
You have purchased already.
Responded 3. Purchase the land from Shalini Bhakot, my lord.
So you
With so low value.
You need to get that sale deed set aside.
It is carrying, my lord. I am hopeless, but so poor person, my lord. They are forcing my portion of land is sold.
Understood,
The
Mr.
original
Das.
actor of the land, Kuhira,
Mr. Das, I've allowed you 10 minutes, enough. But now let me pass the order. Other councils are also waiting. You don't have a
Give me
case.
direction, my lord.
It is, Mr. A. Das, like you say that your case is hopeless, I also say that your case is hopeless.
Give me direction, my lord.
I'm not going.
Give me direction. Give me direction, my lord. My lord,
Now take your seat. Take your seat.
kindly see, my lord. Page
Enough.
16.
Take your seat.
Page 16.
You take your
May I
seat.
read
No.
in SMS?
I am not going to read anything. Take your seat.
Always, my lord.
Heard Mr. A. Das, the learned counsel, appearing on behalf of the petitioners. Miss AG, who is AERC? Who is appearing? Anybody? No.
I am for 6 years.
AGCL, who is there?
I'm there. Respondent number.
Miss A. Pukon appears on behalf of the number 3. Appears for the respondent number 4 and 5. And Ms. So-and-so appears on behalf, Mr. So-and-so appears on behalf of the respondent number 6. petitioners herein have approached this court seeking appropriate directions upon the respondent number 3 to acquisition the land of the petitioner at measuring 1 bigha 10 lechas covered by Dag number 9, Patta number 116 of village Nagaon under Kamalpur Revenue Circle in the district of Kamrup Rural and pay the compensation. First, the brief facts on which the instant writ petition have been premised is that the petitioners are the owners of a plot of land at measuring 1 bigha 10 lechas covered by Dag number 9, Patta number 116 of village Nagaon under Kamalpur Revenue Circle in the district of Kamrup Rural. It is the case of the petitioner that the said land was earlier mutated in the name of their father, late Muniram Saloy, alias Muniram Kakoti. The said land, it is the petitioner thereupon alleges that the said land was illegally mutated in the name of one Srimati Salini Bhagat, that is the respondent number 6, by an order dated 5/1/2015, passed in mutation case number 1460/2014-15 by committing fraud. Subsequent thereto, the petitioner filed a complaint before the Circle Officer, Kamalpur Revenue Circle. And the said mutation was cancelled by an order dated 3/3/2016. And the land was jointly mutated in the names of the petitioners by an order dated 8/6/2016. It is the further case of the petitioner that the respondent number 3 have constructed the Kamalpur power project over the land, and no compensation in that regard have been paid. The petitioner had represented before various authorities, and the petitioner having not received any favorable response, the present writ petition has been filed. This court duly takes note of that pursuant to the filing of the instant writ petition, notice was issued by the learned coordinate bench of this court by an order dated 17/3/2021. Pursuant thereto, the respondent number 2 and 3 have filed an affidavit in opposition, wherein it is categorically mentioned that in the year 2013, the Assam Electricity Grid Corporation Limited, that is the respondent number 3, purchased a plot of land at measuring 5 bighas 3 katha 5 lechas, comprising of Dag number 9 of KP Patta number 116 and land measuring 9 bighas 1 katha 15 lechas, comprising of Dag number 171 of KP Patta number 221. In total, an area of 15 bighas, which is contained in the KP Patta number 116 and 221 of Dag number 9 and Dag number 171 of Revenue Village Nagaon under Moza Karara, P.O. Karara, in the district of Kamrup Rural, Assam. The land have also been mutated in the name of the respondent number 3. Upon the said land, the sale deed have been enclosed as Annexure 1 to the said affidavit in opposition. It is the further case of the respondent number 3 in the said affidavit in opposition that upon the said land, the respondent number 3 have constructed the 132 kV grid substation located in the load center between Amingaon and Baihata Sariali for public interest. In addition to that, the respondent number 3 have also enclosed a communication dated 2/1/2017 wherein it is mentioned that as per the report of the Latmandal and Sadar Kanunga, it appears that the names of the petitioners were mutated in Dag number 9 of KP Pata number 116 under Moza Karara village, Noga. Further to that, Sri Sandeep Kumar Bhagat purchased 14 bighas, 1 katha, 5 lechas of land from co-patadars, that is, Atwar Rahman Soikia, Tazul Islam Soikia, Tazu Soikia, Safizan Soikia, aforesaid Dag of from Dag number 9 of KP Pata number 16. In addition to that, Sri Sandeep Kumar Bhagat have also purchased 3 bighas, 2 katha, 1 lechas from Sri Devendranath Saloi and 4 bighas, 4 katha from Ayub Ali. In total, 22 bighas, 2 katha, 15 lechas stood in the name of Sri Sandeep Kumar Bhagat. On 16/8/2014, 5 bighas, 3 katha, 5 lechas covered by Dag number 9, KP Pata number 16, mutated in the name of AEGCL from Sri Sandeep Kumar Bhagat. Further to that, in addition to that, it was also mentioned that Sri Sandeep Kumar Bhagat and Sri Salendra Bhagat had not purchased any land from Sri Biren Saloi and Damodar Kakoti. The respondent number 3 had purchased total land at measuring 15 bighas from Sri Sandeep Bhagat. The respondent number 6 have also filed an affidavit in opposition. Then it is mentioned that she had purchased 1 bigha 10 lechas of land covered by Dag number 9 of KP Pata number 116, situated at Revenue Village, Nagaon under Moza Karara in the district of Kamrup, by the registered sale deed number 336 dated 1/3/2014, registered on 6/3/2014, from her vendors, Sri Biswajit Kakoti and Sri Amba Kakoti. And since then, the respondent number 6 is in exclusive actual physical possession of the said land. Sale deed have also been enclosed to the said affidavit in opposition. The learned counsel appearing on behalf of the petitioner submits that these sales which have taken place by the sales which have taken place by which the respondent number 3 had purchased 15 bighas of land, as well as the sale by which the respondent number 6 have purchased 1 bigha 10 lechas of land, are all fraudulent deeds of sale. And as such, the petitioner is entitled to the compensation. This court have duly given an anxious consideration to the respective submissions and have also perused the materials on record. From the perusal of the materials on record, it is seen that by the deed of sale, the petitioner, the respondent number 3 have purchased 5 bighas, 3 katha, 5 lechas of land from Dag number 9 of KP Pata number 16 and 9 bighas, 1 katha, 15 lechas from covered by Dag number 171 of KP Pata number 221 from one Sri Sandeep Kumar Bhagat. The said sale deed have not been cancelled or have not been challenged or cancelled in any proceeding, have not been, the said sale deed still holds the field. It is the specific case of the respondent number 3 that upon the said land at measuring 15 bighas, the AEGCL have the respondent number 3 have constructed the 132 kV grid substation. Taking into account in addition to that, this court also takes note of the deed of sale dated 1/3/2014, executed by Sri Biswajit Kakoti and Sri Amba Kakoti in favor of the respondent number 6. The said deed of sale, unless it is being cancelled, the said deed of sale unless cancelled in accordance with law, the respondent number 6 has title over the said land. Considering the above, this court cannot direct the respondent authorities to acquire the land of the petitioners, inasmuch as the respondent number 3 have purchased the land via a deed of sale dated 11/12/2013 and thereupon have constructed the 132 kV grid substation. So accordingly, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed. So before parting with the record, it is observed that the dismissal of the writ petition shall not preclude the petitioner to approach the competent court of civil jurisdiction, if so advised, challenging the sale deeds.
Give me direction, applause, my lord. Give me direction, I will cancel the deed
Ah,
for the interest of justice, my lord.
yes, Mr. Datta.
Well, except for that blacklisting part,
I know
holiday
that.
listing, that is the only issue, well, in my submission, well, that remains to be adjudicated. Rest of the matter, Millard, that can be agitated before the other forum. Because since there is an arbitration clause and they have also taken a plea that there is an arbitration clause, so the matter should go before the arbitrator.
No, we are only concerned because the blacklisting has now been removed.
Yeah, but there is a part, yes.
The earlier part has
Yes,
continued.
yes.
So therefore, on that basis, why should we interfere? Issues on that?
But that, Millard, practically, even going by their own set of rules, Millard, there has to be some sufficient notice. There has to be indication in the notice that they are going to take the decision for putting me under holiday list. Nothing of the sort was there. So expressing, Millard, it is in violation of the principles of natural justice.
What is the notice we should? Where is the impugn order?
Page 103 is the show cause, Lordship.
Yes.
Your Lordship will kindly see the second paragraph. Numerous communications. Numerous communications were made with Messrs. TEPL on regular basis regarding instances of insufficient workforce presence at the site, often without prior notice to so-and-so department. Despite repeated follow-ups, the contractor has not shown any seriousness in addressing both the progress of the job and quality of construction. In many cases, so-and-so department have had to dismantle completed work such as floors, beams, etc. So-and-so have been invited repeatedly for meetings. Well, these are general discussion of what the transaction between them has taken place. And last but one paragraph, 104. Considering the above, you are now directed to show cause within 10 days from receipt of this letter as to why NRL should not initiate the following actions against so-and-so for failure to meet contractual obligations and violation of terms of CGC. First is terminate the contract, forfeit the payment deposited against the contract, initiate any other penal action as per tender terms, NRL
Where
policy.
the order? Impugn order?
The impugned order, your lordship will find at page 144, 2nd January 2025. Second paragraph. This is also to inform you that your firm has been put in the holiday list for a period of 1 year with effect from the date of
This is, yes, sir. A period of 1 year with effect from the date of issue of the letter
This-
for the reason that poor performance of
this
the
letter
agency
for
is
the
one
reason
of
that poor performance so-and-so, as per NRL's policy for holiday listing. Now, NRL's policy for holiday listing, your lordship will find, we have filed an additional affidavit.
That is the older policy. There is a new policy.
Okay. Well, my friend says that, well, there is a new policy, but then
And that policy which is annexed is not the actual policy.
now, as per our knowledge, Miller, we have annexed a policy in our rejoinder. Additional affidavit we have filed. In that affidavit, we have given the policy.
Yes, what is it?
My lord, may,
As per the new policy,
as per the new policy, my lord, I did not have any knowledge of it, my lord. It is coming only for the first time today. But in the new policy, copy this one again. Well, there is second page, reasons for holiday listing. An agency may be placed in holiday list for any or one or more of the following circumstances. If the agency has, in the context of its dealings with the corporation, has breached the code of integrity, indulged in malpractices, submitted fake, false, forged documents, submitted materials in lieu of materials supplied, deliberately
it is
violated
under I, 2.1I.
poor performance of the agency in one or several contracts.
Now, what
Poss-
have you done as regards the termination? Have you challenged it?
My lord, we also filed an appeal. My lord, during pendency of this writ petition, my lord, the appellate order has also come. But in the appellate order, they have, except for modifying the holiday listing order, from the date of the appellate order, it has been removed. They have not interfered with any of the decisions.
Understood. Now, are you challenging it or not?
Yes, that is also in challenge in the writ petition.
But
Their termination order itself is in challenge. Their decision to terminate the
on
contract.
what ground?
Well, first of all, their assessment of poor performance is based on two premises. Namely, first, I moved in the materials at a later point of time, which I say in my response and in their communication to the authorities that it was attributable to them only, because I wanted my access. It was given to me at a much later point of time. There was administrative lapses on their part in allowing me entry to the area where construction was to be conducted. And so far as the other aspect of the allegation in the show cause notice says that some of the times the materials were not, the construction was of not of up to the desired level. Sometimes it had to be brought down. It had to be dismantled because of my lack of performance. The construction was normal. That is an area, my lord, I would submit. It requires a determination inter se between the parties, because perhaps since there is allegation and counter allegation, my lord, that may not be possible in the writ proceeding. The reason being that, my lord,
Mr. Dutta, we are considering on the perspective of blacklisting.
On the, yes, on the point of blacklisting, my lord, my submission is that, my lord, now
Now,
that
what have you done as regards the arbitration?
arbitration, my lord, the process has not yet begun.
Why?
That probably, my lord, the petitioners are in the hope of getting some relief here so far as the blacklisting is
Are
concerned.
you challenging, no, forget about blacklisting. You have to give me a handle for allowing, for giving you relief. But if you are not helping me out this court, it seems that you are not aware of the law.
No, here, my lord,
What is the judgment you are bringing today?
no, my point,
No, Mr. Judge, what judgment you are placing?
as far as, my lord, the holiday listing is concerned, my lord, I am limiting it to that point only. My lord, I'll be relying on,
My question is, what is your submission? What is
I'll
your-
be relying
which law you are referring
my lord,
to?
I'll be relying on blue dreams.
Yes. Now, what does in Blue Dreams it is say?
Now, my lord, if I,
In Blue Dreams, it is say that if there is a bona fide dispute as regards this, then the question of holiday listing or blacklisting does not arise, isn't it? So therefore, where is the bona fide dispute you have raised?
my lord, the dispute is that, my lord, if your lordship will kindly see my
Because if you are saying that, okay, I am not going into much into this as regards
No, no.
termination here, that means if you are not going into, then are you challenging the termination or not?
No, my lord, the challenge to the order of termination is there in the writ petition. What I am
No,
on,
but what it is, means the moment you are saying that you are going for arbitration and all this thing, my question is, once you make that submission, you are not referring to, or if you are insisting on the termination out here in the writ petition, it is good. I can look into it and say that, okay, I cannot entertain it. Let's
no,
look
my lord,
into it.
not only,
But if you know it, that there are disputed questions, why you are not referring to going before an arbitration?
no, that,
There's no bona fide dispute.
my lord, that remedy, my lord, is available in
Merely
the petition.
because filing a writ petition out here that you have not done this, which cannot be decided when there you have an alternative remedy or an efficacious remedy by in way of what you call the filing a proceeding under the arbitration. If you are not challenging that, then obviously where is the bona fide dispute?
No, my lord, their impugned order is classified into too many aspects. First of all, they have cancelled my contract. They have put me on holiday list. They have also directed for forfeiting the money. There is a according to us, my lord, there is a substantial money available with them, which is around 20 lakhs or something. That they are also not going to release it on the ground that till the time the issue is decided, that money will not be released to us. This is not of some current expenses. These are of old bills. They are also holding up these bills. Everything was put to challenge in the writ petition, my lord. Rightly or wrongly, my lord, that is the challenge. My submission is that, my lord, taking a cue from not only Blue Dreams, my lord, there is yet another decision which I will like to place before your lordship, the daffodils case. There also, my lord, the common thread is that, my lord, it has to be, if you are going to take a drastic decision like putting me under a blacklist, but then you have to follow certain principles of law, some certain principles of natural justice. Here, your lordship has seen, my lord, in the show cause notice, there is no whisper that they are going to take this, except for the reason that NRL policy in the contract. And now, my lord, I'm getting to see that in this policy, but the general conditions of contract which was supplied to us and the terms and conditions of the policy which were with us, my lord, at the time of the commencement of the contract, that does not indicate.
When did the contract start?
16/1/2023. And one aspect, my
If
lord,
that is so, if you are not
No.
aware of a policy which was
no,
in existence
Anna,
from
apart
2022,
from it,
what
my
will
lord,
help you?
apart from it, my lord, there in the old policy also, my lord, there are authorities prescribed as to who can take the decision. If I can take your lordship to the rejoinder affidavit, my lord, the additional affidavit. If your lordship will kindly see.
Mr. Deka, who has taken the decision? The decision must have been taken not by the
This is
communication.
going away from this for a moment, my lord. He was placed in the holiday list on 2nd of January 2025 and removed on 24/10. Now he is seeking removal with retrospective effect from 25/1, 22/1, my lord. My lord, I have brought on record in the affidavit in opposition, my lord, in respect of another contract. He is already in the holiday list with effect from 29/1/2024. And
It's
in,
not challenged.
he has not challenged. And in the reply affidavit, he said that that is not relevant, my lord. So even if your lordship interferes today with the holiday listing with effect from 2/1, he continued till 26 January 2026. Otherwise, in connection with the other contract.
Maybe that may be true, but for this purpose, if I interfere, he will continue. So how the.
That period is already over. Now he will suffer no prejudice. Now, if he participates in a contract, we cannot say that we will not consider him because he was earlier placement.
But still, Miller, that remains as stigma.
It will not remain as a stigma.
They are
It does not.
already stigmatized in the earlier contract. There is no difference.
Miller, at least,
I
Miller,
think this is a case for dismissal with cause. Do one thing, those MSc case, we have a lot of MSc. In each of the MSc case, how much cost I am imposing, that shall be bared by Mr. Doctor's client. You need not wait for that. You are dismissing it right now, but the computation of the cost will be, you will be knowing it after I dispose of the.
that will cause too much injury, Miller.
Necessary. You have no business out there. You want to go to the area, whatever may be, you are already blacklisted.
No, Miller, so far as the issue of
Then
this.
why didn't you raise that issue out there? You are basically on this point that in that show cause notice which have been issued, there is no mention whatsoever that you are going to blacklist him.
And another aspect also, Miller, under their policy, Miller, yeah, I'm just showing it to your lordship. If your lordship will kindly have the GCC.
We may direct one thing, we may set aside that thing and allow them to again look into and then do.
That liberty, but as of
Again,
date, my lord,
then they will have to do it prospectively now,
Yes.
which means you may lose now. The moment I set aside the earlier period, now it will be prospective. Would you like to do that?
No, Miller.
No, it will be prospective. It cannot be earlier because I can't take that. The moment I set aside that, that portion remains removed. It is gone. So now I've asked him to look into this and do it freshly. That
No.
is because I cannot say that it cannot be once. Okay, your basic ground is natural justice. Natural justice, okay. Natural justice is there. For that, what is the requirement is you have to be given an opportunity. Very well, they will give you an opportunity. But if they blacklist you, it has to be prospective. You take that risk.
No, Miller, that will be little
No,
difficult.
no. Therefore, normally this type of litigations don't come. But the moment you are raising that issue of principles of natural justice, I have to give you, I have to set aside that. That set aside is gone, period. Once that period.
Now, if your lordship is going to give them fresh liberty, Miller.
Yes.
In the
Yes. And once I give them the liberty, because obviously liberty has to be given,
no, Miller, since their decision has been now.
then there is no point of setting aside.
No, Miller, their decision.
It has become infructuous.
it has
No.
become, actually, it has become infructuous, my lord.
Their decision on the holiday listing has been qualified by an appellate order. Now, if your lordship is going to interfere with it on the ground of principles of natural justice and also on the ground that it has been issued by somebody who, as per
Whatever may be. So now proper authority will do it. But this has to be prospective.
no, that
may not
no,
do it,
my lord,
It has to
prospect.
be. It has to be. No, Mr. Doctor. That has to be.
We may not do it, my lord, that's a different matter,
No,
but
they may not do it. That's shall look at. But I have to give them the liberty. And the moment I give them the liberty, they will initiate. Once they initiate, then the question will be to pass an order.
No,
Once they pass an order, they may
No, prospective, it cannot be from today,
Because
Milord.
they overlooked the fact that you were already blacklisted.
Yes, yes.
Otherwise, what was the
That
necessity?
was no necessity actually,
There was no necessity itself.
because that
So
period
therefore,
covered.
I let them, give them an opportunity for doing. So better withdraw with liberty to approach the
Yeah, arbitral tribunal.
forum wherever you feel like as regards the, nothing more than. Else takes the cost in each of the contempt.
Milord,
And I give you the liberty I give.
Milord, in that case, can I have 10 minutes? Just to have the instruction.
Yes.
Just to
You
have the
don't
instruction.
require an instructor. Anybody would say that let us withdraw this petition.
No, Milord, since Milord, the question now prospective, if they want to go prospectively, Milord,
Yes, prospectively.
that cannot be today. That cannot be, that can.
No,
in
that
all-
cannot be there because the moment I set aside, once I set aside, it is
Effect is gone.
it is non-est. Once it is non-est, they have a right. Let them initiate the right.
But that will be only for that period.
Whatever may be, so they will now do it prospectively. You see, now if they take a blacklisting, they say, now we are blacklisting you for that earlier period. No, the order has to be prospective. You take that risk.
So that
You have a very
that-
strong case, go there.
Milord, in that case, it will be inflicting a second punishment.
No,
Milord.
because the moment you are making that submission, therefore I was asking you, whether in this case have you filed the arbitration proceedings? Once the arbitration proceedings are there, then the question arises, but you are there, here submitting to that effect. Better go there. There's no use.
So in that case, Milord,
I allow your petition in that regard.
Regarding that liberty to approach the arbitral tribunal, and
I allow your petition. Granting
no,
of the-
no, in that case, Milord, your lordship may allow me to withdraw it. Milord, I can raise everything before the arbitration tribunal.
Heard Mr. S. Dr. the learned senior counsel assisted by so and so appearing on behalf of the N. Decca appears on behalf of the
all the respondents.
appearing on behalf of by so and so appears on behalf of
Not only.
the respond
respondents,
number
up to
1 to
seven.
7.
1 to 7.
The present petition has been filed by the petitioner, assailing the termination notice dated 27/11/2024, by which the contract awarded to the petitioner by work order dated 15/12/2022 was terminated at the risk and cost of the petitioner, semicolon. Or setting aside the communication dated 2/1/2025 issued by the manager commercial NRL, placing the petitioner in the holiday list for a period of 1 year. As well as the communication dated 30/5/2025 issued by the senior manager bracket production in-house NRL, whereby processing/release of RA bill number 2 was made contingent upon the adjustment of the alleged recoverable dues towards risk and cost. The petitioner also have sought for a mandamus directing the respondents to forthwith release the admitted dues to the tune of rupees 20,65,231.90, as well as other withheld dues. This court duly takes note of that in pursuant to the order passed by this court on 10/9/2025, the respondents have duly put in their appearance. In the meantime, while the writ petition was pending, the petitioner have also preferred. You preferred the appeal earlier.
Earlier.
In the meantime, it is further relevant to take note of that prior to approaching this court by filing the writ petition, the petitioner had already prepared an appeal. And the said appeal before the appellate authority. And by an order dated 24/10/2025, the appellate authority passed an order had preferred an appeal only in respect to the in respect to putting the petitioner in the
No,
holiday
There were
list.
two representations, one against the termination and one against the holiday listing,
I had filed two appeals.
two separate representations. 17-1, I think.
One appeal was but related to termination of the contract at the risk and cost of the petitioner, as well as the other appeal pertains to putting the petitioner in the holiday list. By an order dated 24/10/2025,
नहीं आता है।
the managing director of the respondent company had revoked the order dated 2/1/2025, thereby placing the petitioner in the holiday list for 1 year. With immediate effect.
Shalom, may I just indicate one thing? One is representation and one is appeal. The first representation was, both are dated 17, but instead of two appeals or two representations, your lordship may
Where is
indicate,
the other one?
One
Other
is-
order?
one is at page 145, one is at page
150.
150.
No. What is this? I have at page 196. 190. What is that document? And where is the other order?
No, there is only one order passed, my lord.
The other order appeal representation, not disposal.
No,
You said that it has been rejected.
the appeal.
Appeal has not been rejected. Appeal
On-
has been allowed.
Appeal has been allowed only with regard to that particular date.
So considering that over 10 months have already passed, the period undergone is viewed as sufficient in the prayer. Accordingly, that so-and-so is revoked with immediate effect. The name of so-and-so shall be deleted from the holiday list, the website.
Yes.
Then
That-
nothing remains there.
No, there, my lord, the representation was against, one representation was against cancellation of the termination, and the appeal was against the blacklisting. So on same date, my lord, two correspondences were there.
What is the date?
Same,
17/1/2025.
Pursuant to the petitioner, pursuant to the impugned communications, preferred an appeal challenging the order of holiday listing the petitioner. The appeal was dated 17/1/2025. In addition to that, the petitioner submitted a representation to the respondent authorities to reconsider the termination of the petitioner with risk and cost. Insofar as the appeal filed by the petitioner on 17/1/2025, order was passed by the managing director dated 24/10/2025, thereby revoking the order dated 2/1/2025, whereby the petitioner was put in the holiday list with the specific direction that the petitioner be deleted from the list of holiday listed contractors displayed on NRL website and internal records. Next. Insofar as the representation submitted for reconsideration of the termination of the petitioner, the same have not been considered. It is the opinion of this court that as the petitioners the order dated 2/1/2025, whereby the petitioner was put in the holiday list, no longer survives. There is no requirement of any further entertaining the instant writ petition on the said issue. This court also takes note of the challenge to the termination order at the risk and with the risk and cost of the petitioner. It is the specific allegation of the respondents that the petitioner have not been able to carry out the work even to the extent of 50%, resulting in huge losses to the respondents. On the other hand, it is the specific case of the petitioner that it is on account of the failure on the part of the respondents to provide, to comply with their reciprocal obligations, contractual obligations, the petitioner could not carry out the work. These are questions of facts which can only be decided in a forum wherein evidence can be led. This court also takes note of that there is an arbitration clause whereby such disputes can be resolved. Considering the above, this court therefore disposes of the instant writ petition with the following observations and directions. Number one, the challenge to the interim order, to the order dated 2/1/2025, whereby the petitioner was put in the holiday list, no longer survives in view of the order dated 24/10/2025. Insofar as the challenge to the termination of the contract at the risk and cost to the petitioner, as well as the consequential actions on the part of the respondents in not releasing the various payments. It is the opinion of this court that such disputes can be resolved by way of arbitration. Accordingly, there is an arbitration clause. Yes.
Page 270.
Page
270. Clause 8.7.2.
which is clause 8.7.2. Of the, what is this?
General conditions of contract.
Huh?
The
General
GCC,
conditions
general
of
conditions of
Of the
contract.
general conditions of the contract. Under such circumstances, the petitioner is granted the liberty to initiate appropriate proceedings for redressal of the petitioner's grievances as regards the termination of the contract and other consequential actions by invoking the arbitration clause as mandated in clause 8.7.2 of the general conditions of the contract. Next, this court further observes that the non-entertaining that this court having not entertained the disputes pertaining to the rejection pertaining to the termination of the contract at the risk and cost of the petitioner and other consequential actions on the part of the respondents shall not preclude or prejudice the petitioner in such arbitration proceedings.
I received
Is there a matter about?
My lord, the holding of the first meeting of the Gaon Panchayat
Oh, yes.
without serving the written notice. my lord. On the last occasion, 46, my lord.
Huh?
46.
You have a good case
My lord.
because Mr. Bonik wanted to delay this matter on the last time when it came. Did this?
well, that notice, well, that petitioner says that that notice has not been served. Well, it was served through the WhatsApp as well as well, the physical copy also given on 26, 2025.
What is the petitioner name?
Lordship petitioner name, one is Malad
Azmira Sultana.
Sultana, another is Lordship Mohammedul Islam. There is a mark Lordship. Taslima was served on my lord 18/6/2025 through WhatsApp. There is a WhatsApp group, Lordships.
My lord, there is no provision of serving notice through WhatsApp, my lord.
Next is Lordship. So the
You admit that you have received it.
My lord.
Lordship physical copy
No,
also.
no, I have not admitted, my lord.
Then there's no provision why you are saying.
Yes, my lord.
A physical copy also be served, my lord. It was received by the husband of the my lord, the petitioner.
Where is the receipt?
Lordship, that is Lordship, last page, Lordship. On 26/2025.
Want to sign, my lord?
Huh?
Sign to want to.
What is the husband name?
Lordship, Mohammedul
Hassan.
Hassan.
And the petitioner,
Other petitioner is number 2, Lordship, the Mohammedul Islam.
this is for distribution of winner certificate and letter of oath taken.
Lordship, that,
This
next
is
page,
different.
Lordship, that notice, Lordship, that is
What?
16/2, Lordships. 17/6/2025.
I've asked somebody to produce the records of the first meeting.
Of first meeting record, not limited, only valid that regarding my lord, that one, Lordship, whether the notice has been served to the my lord, the petitioner or not, ask me to produce. And the my lord, the record, my lord, the first meeting.
First meeting
record
record
my
is
lord,
there
the
at page
regular-
71 of the affidavit filed by the private respondent, my lord. Page 71 is the typed copy. And from 82, lordship will find the vernacular version where our name does not appear, my lord.
First meeting of newly elected so and so. Who is there? Petitioner not there.
Yes, madam.
And how many members are required? It's a 10 member. How much are? So 1, 2,
Grounds of 10 members.
3, 4, 5, 6, 7 are there.
8, 9.
3 are not there.
1, 2, 3. 3, 4, 5, 6.
You to take the oath.
No, my lord. I was not in the meeting, my lord. After the meeting, I come to learn about this, my lord. This is in respect of distribution of winner certificate, my lord. And letter of oath taking. Not for the first meeting, my lord.
What is this document? Page 92, 90. And what is this page 89, 88? 87.
The oath, my lord, taken by the ward members, my lord. Oath of affirmation.
No, these are understood. But why the name of the petitioner is mentioned at page 89, 88 and 89?
88 page number 8.
88. Why this document is being translated? What is this document?
These are the, my lord, the oath taken by the
No, why
petitioners
it
as
is
ward members, my
translated?
lord.
Means oath has been taken by you.
Yes, my lord.
Then why you are saying that oath has not been taken?
On 11/7/2025, my lord.
Huh?
On 11/7/2025, we took the oath, my lord.
And then when was the first meeting held?
First meeting was held on 3/7/2025.
You took the oath subsequently.
Yes, as ward
And
member,
others took the oath on
as per page 80.
3/7.
Yes.
Okay, so you did not. You took
It
the
was
oath.
on 11/7. 11/7 and first meeting
Now,
was,
what do you want?
my lord, I want to hold a fresh meeting, my lord, in terms of rule 46, my lord.
You file an appeal.
Right.
File an appeal because the district judge, district commissioner under rule 6, na?
My lord,
Rule 6.
my lord, since written notice was not issued, my lord.
They have twofold prayers. If they go for the first prayer, that I am not qualified to be a member, then it
This
will
is not
get
my
an
prayer,
appeal
my
order.
lord.
It will be tribunal. Tribunal limitation over. Now the entire pleadings is touching upon my election as the president. The moment you touch upon the election as the president, and now their submission is no, you are qualified as a member. We abandon that part, although it's not on oath. I accept it. Your election as a president is bad because of Rule 46 not compliance. So far as compliance or non-compliance, it's for the district commissioner to persuade the court by the record. I cannot say that. Although I know, but I cannot say. When a matter of compliance comes, essentially touching upon and the challenge to my election, the president, then section 11 of the Assam Panchayat Act has to be read conjointly. Because if you are touching upon my election as the president and not on service of the notice simpliciter, then again you have to approach the district commissioner, putting a challenge. Look here, sir, election has been done of these two persons without the service of notice. From the records, either it stands or fails. That has not been done. This is a statutory requirement on the touchstone of election. Therefore, it cannot be obligated by writ. That's my submission. They have to take a call. Now he's coming clean. Me as a member, it's okay.
Yes, my lord.
That if they had a reservation, they took a note on 11, and as my friend would say, notices were served. They do not dispute the WhatsApp. They do not declare the WhatsApp. Now, once it has come out, they feign ignorance. Anyways, when it touches upon my election, it has to be section 11. If I may read once for a moment.
Section 11 or
Section 11.
6?
Section 11. If I may read once. Any challenge without touching upon my election would be different.
Election to president.
My lordships.
Have any dispute relating to the validity of the election of president and vice president shall be decided by the deputy commissioner.
Now, this is more so because the prayer in the writ petition A at page 19. Page 19, Mega. They pray for Rishabh Sachirai for setting aside quashing the impugned election of respondents 5 and 6. Here, my lord, it's section 11, not 226. They challenge my election. B, mandamus be not issued directing respondents to forthwith cancel, resign, cancel, impugn election. C, certiorari for setting aside and quashing the impugn proceeding of the first meeting, touching upon the election. D, mandamus shall not be issued directing respondents to forthwith cancel, impugn proceeding of the first meeting. Gone. E, mandamus shall not be issued directing respondents 3 and 4 forthwith convene first meeting. Now herein comes the.
And when did they file this writ petition?
They filed this writ petition precisely on 14/11/2025. It was done.
21/11.
14/11.
21/11.
Maybe filing. We go by the oath. And therefore, they took oath.
14/11 authorized. Filing is on 24/11. 24/11.
And if they took an oath on 11th of
you have been waiting all this while.
July.
After taking oath on 7th. My goodness. It's your handiwork. Otherwise, why will this person come before this court? They were all happy out there. No case.
My lord, my case is, my lord, as per Rule 46.
Why should we go into Rule 46? That can be very well looked into by the Deputy Commissioner. Why should we look into? And almost 1.5 years have gone by.
My lord, there are judgments, my lord, one passed by Lordship and by other coordinated bench, my lord. Regarding Rule 46, my lord, service of notice, my lord.
46 in that case was not complied at all.
In this case also, my lord, a written notice
You
has
are
not.
saying that I have not received. You had the particular year. When there was a clear-cut infraction, in that case, I have done so. Not in this case.
Well, in this case also, my lord, there is no document to show that I have received a written notice before 7 days of the meeting. If they can produce that, my lord, then I have no case.
Take the oath immediately.
Well, I took the oath on 11/7, but 3/7, I don't have that knowledge, my lord.
The oath. You took the oath, waited for 4 months, and then approached this court.
My lord, but my lord, the statutory prescription has not been followed.
Now thereby you are challenging the president now after becoming seeing this that you want to change the president. They had a majority of 7. You are number 2. You have only 2.
But my Rule 46 has not been followed, my lord. It has to be followed.
Why should I decide? It is a question of fact. Whether it has been followed or not.
My lord, there is no document to show, my lord. There is no document to show on our records that the Rule 46 has been complied with. If they show any document that I have received the notice prior to 7 days, then I have no case, my lord. But in this case, my lord, there is no such notice.
Take it up with you should have gone before the district commissioner. He has the authority to look into these factual foundations as to whether.
In the same fact, my lord, the 2 judgment has been passed by this honorable court, my lord.
So what?
And in one case, my lord, it is held that
dissimilarity in the facts changes the whole. What is the words used by the Supreme Court in 1970? A slight difference in the facts or a slight dissimilarity of the fact changes the entire equation of the game. There cannot be a ratio on this aspect. Depending on facts. In your case, why did you sleep for 4 months? wrong case. This court should not. Anyways, we do one thing. Saying granting the liberty, go to the deputy commissioner, let the deputy commissioner decide. Maybe file an appeal before that, and he will look into the records and do whatever it is. Better.
As per section 11, my lord.
The only power. And why you the challenging of the president? Why you are making that president? You challenging the president on what ground?
Now, there'll be two parts. Once they say, because I held some office rightly or wrongly, then they're challenging me as a member, my election as a member.
Where is the challenge as a
My
member?
lord, his
They-
membership is not under challenge, my lord.
I could read out the paragraph.
Membership is
No,
not
no,
under
no,
challenge,
no,
my
no,
lord.
Not that.
Ward membership is not under challenge.
You
Very
see, the question is like this. If he has certain, if he enjoys an office of profit, another place, if he as a member, he lost his chance out there. Taking into account that he did not raise that issue at the time of scrutiny. Therefore, as a member, challenge cannot happen.
Gotcha.
There can be a very well a challenge as regards the president, because here the words starts in section 111
11.
that there shall no president, vice president, or any member
Gotcha.
shall be elected out there who holds so and so, so and so.
Yes.
Gotcha.
So therefore, the president comes under 46
Correct.
subsequently, or section 10. So
46,
section 10,
yes.
which does not go to the scrutiny process under the Representation of People's Act. So you can very well challenge
Absolutely.
that. I made it clear in that judgment itself.
And there is no limitation attached to this. Unlike in the election tribunal,
Ah,
there is no limitation attached to
there's
this.
no limitation.
Because-
There's no 243O.
Because it's a matter of record.
ISA Khatun lordship held that.
No,
under
no, not
ISA
Isa
Khatun, my lord.
Khatun, the other one, the next one, the third.
Firdaus.
In
Firdaus was on
in
that.
that thing, while deducing what I said in Isa Khatun, I made it clear that this shall not apply insofar as the election to the president or the vice president.
Lordship.
However, in that case, there was a challenge so made, although there was a main challenge made to the president or the election, but there is also an intermediate challenge to the president in here, which I say it being a question of fact which cannot be decided, because I need to have the two aspects. One is for issuance of a writ of quo warranto, there is a requirement that it has to be a public office. There is no quarrel with that.
Oh, yes, third party can come into it in a quo warranto.
And the second is the necessity that he has usurped the public office having no authority. For its usurping, that is a question of fact. How can I decide? That is this.
Absolutely.
There's the beautiful judgment of 1963, 61 I have referred to.
My
I think Justice Rajendra Khatkar, how he culls down what is the writ, when a writ of quo warranto. And Lord Halsbury has made an opinion. What he was trying to do, he could not do one thing. Say the writ petition was premised in such a manner that the challenge was to the membership. But intermediately he's challenged this one. And the moment that if I hold it here, that he cannot, because of the violation of say Rule 62, he cannot, then his membership also goes. But then there is the opinion of the words of Lord Halsbury, who says that you cannot do something which you directly, you cannot do indirectly. Anyways. Heard Mr. R.M. Beka, the learned counsel, appearing on behalf of the petitioner, Mr. Petitioners, Mr. S. Dotto appears on behalf of the respondent number 1, 2, 1 and 4, 3 and 4. One so appears for respondent number 3 and 4.
I come for 5.
You are for 5.
5.
Huh?
He's with me.
Assisted by.
No, it's okay.
Assisted by, nobody for 6
Service is complete, my lord, but he is not appearing.
and 7.
My friend.
The present petition has been filed challenging the election of the respondent number 5 and 6 to the post of president and vice president of 19 Kothalbari Gaon Panchayat in the first meeting convened on 3/7/2025, as well as for other consequential directions. It is the specific case of the petitioner that though the meeting was convened on 3/7/2025, but the petitioners were not informed by issuance of proper notice as is envisaged under Rule 46 of the Assam Panchayat Constitution Rules 1995. On the other hand, it is the specific case of the respondents that due notice was provided to the petitioners. And the petitioners very well knew about this meeting and intentionally did not participate. Takes note of that, note of section 11 of the Assam Panchayat Act 1994 as amended. By the Assam Panchayat Amendment Act 2023, whereby it is mandated that any dispute relating to the validity of the election of the president and the vice president of the Gaon Panchayat under the Assam Panchayat Act 1994 shall be decided by the district commissioner. In the instant case, there are questions of facts to be decided as to whether there was due service upon the petitioners. This court have also taken note of that the petitioners have taken oath on 11/7/2025 and thereupon had approached this court by filing the writ petition on 24/11/2025. Taking into account the above, this court is not inclined to entertain the instant writ petition, inasmuch as the petitioner have an alternative and efficacious remedy, wherein disputed questions of facts as to whether the petitioner have been duly served the notice or not can be adjudicated. Accordingly, the instant writ petition therefore stands dismissed on not being entertained. Before parting with the record, this court, however, observes that the dismissal of the instant petition shall not preclude or prejudice the petitioner to approach the district commissioner, which
South Salmana, Mankasar.
Mankasa, in terms with section 11 of the Assam Panchayat Act 1994. So it is observed that there is no limitation.
No limitation. My lord, liberty can be given if my lord there is adverse order.
Read the last line.
No, after my lord, this is my lord decision, my lord.
I'll say that before parting,
Yes, yes, yes.
say that shall not preclude or prejudice
My
the
lord.
petitioner to approach the district commission. Anything else?
If my lord, this is order goes against me, my lord, in that case. They pass any
Immediate
adverse order.
fresh cause of action.
Yes.
We don't expect it.
Obliged, deeply obliged. The petitioner was a signalman in the Indian Army, during which he committed the offense.
Yes, what are the terms? What is the law in this regard?
Yes, Lordship, there is a recent judgment of the Supreme Court in Rohit Chaturvedi. It says that firstly, the gravity or the nature of the offense cannot be a sole consideration. That is the first aspect. Lordship, as far as which are the considerations that are to be taken in account, there are two older judgments. One is Lakshman Naskar that I'll place. Those, Lordship, delineate the conditions that are required to be considered. And that is not only gravity of the offense, there are certain other things.
What does he say?
Lordship, Rohit Chaturvedi, Lordship will have para 7.
Yeah?
7, para 7. May I read, Lordship? Yes. Reverting to the present case, the faint ground invoked by the Respondent Union of India in support of rejection of the petitioner's plea for premature release is that the crime committed by the petitioner was a heinous one. We wish to make it clear that in a constitutional polity governed by the rule of law, the denial of remission cannot rest solely on the ground of heinousness of the crime. As we have already stated above, remission is not an extension of the sentencing process, but a distinct executive function concerned with the present and future, namely the prisoner's conduct, evidence of reformation, and prospects of reintegration into society. To predicate its denial only on the heinous nature of the offense is to collapse this distinction and to reconvert
remission into the retrospective reaffirmation of guilt, which the criminal justice system is already adjudicated upon. The gravity and heinousness of the offense cannot stand exhausted at the stage of sentencing, and the judicial determination of punishment necessarily incorporates these considerations. A criminal justice system that refuses to look beyond the gravity of the offense to the offender's transformation will betray its reformative ideal, particularly at the remission stage. Justice does not permit permanent incarceration of an individual in the shadow of their worst act. Now, Lordship will also have 7.1, which summarizes it. The nature of the offense cannot, therefore, be the sole ground for denying remission. Emotive retribution is a course incompatible with constitutional values. The decision on remission must emerge from a holistic assessment of the prisoner and after balancing societal interest with the prisoner's right to be considered for release on fair and reasonable criteria. Lordship, this fair and reasonable criteria has been enumerated in two other decisions that I will just place, Lordship. One is Lordship Lakshman.
Yes.
Lordship, if I understand correctly, Lordship, the clemency cannot be a matter of right. Only once needs a consideration.
There's no quarrel with that. Not a matter of this, but upon application of law,
Lordship.
it's a matter of right.
Lordship, that has been considered. Lowest pass a speaking order, Lordship.
Now, in this judgment, in the case, it's a recent judgment of 2026. Supreme Court says that you cannot only solely put the emphasis on the question of
Heinous of the crime.
heinousness of the crime. There is a requirement for further looking into as to whether there has been he can be brought integrated to the society, whether there has been a transformation of the person concerned, more particularly taking into account that the person under whom he is staying out there, he has also given something. So therefore, I think, don't you think that in view of this judgment, you need to look into again, re-look into it? That's the
Afresh.
Yes.
That's the only thing.
That's all.
That can be.
That's the only thing. Because here, if we see paragraph 6 of the order, they only refer to the heinousness of the crime. Whereas paragraph number 5 says, whereas the report by the jail authorities revealed as on here, the convict has undergone actual imprisonment of 15 years and has undergone a total sentence of remand, including remission. The report reveals the conduct of the individual has been good and the superintendent of police also recommended for premature release. So this is what is the person who under whose custody he is. He has given a favorable response to him. Now, the response has to be looked into in view of this judgment on the basis of not only heinousness, because the heinousness and this paragraph 6 is barely on heinousness. So we
That a fresh decision
set
that can
aside
be
this,
looked into.
direct you to again reconsider his case.
Lordship, what para 5 does not also say is that the commanding officer who was the convicting court has also said that perhaps his case should be considered favorably. That is first. And secondly, Lordship, if there is a reconsideration, the enumeration of the conditions may be given, Lordship, because Lakshman Naskar, that judgment says that there are certain conditions that need to be compulsorily looked into.
Paragraph 7 and 7.1.
Lordship, that is only whether heinousness of the crime can be the sole offense. But there are some other judgments which enumerate also the conditions that need to be factored in. Yes. Lordship, Lakshman Naskar, paragraph 7. 6 and 7, Lordship.
It's the same thing.
Yes.
Paragraph 8 says the same thing.
Same thing, yes. Lordship, also.
Paragraph 7 says what are the reasons.
Yes.
Paragraph 8 says the same thing. You cannot look into just because of his age.
Very well.
He has the Secondly, there cannot be a reason that because there are witnesses residing out there, still witnesses still alive, they may be cause potential harm. And lastly, suggestion of the incident is not an individual act of crime, but sequel of political feud affecting the society, whereas his political views have changed or still carries the same, so as to commit the committee had not been examined by the government.
Thereafter, that has been slightly expanded by the Supreme Court in one more decision that I will place, Lordship. It's called Rajo. There's another decision, Lordship, of 2023. Para 24 builds on Lakshman Naskar and in a non-exhaustive manner lists out some other considerations. So those also may be considered perhaps. Para 24, Lordship.
A report has also to be taken from the concerned court.
Yes, Lordship, because in this case, it arose from a court martial. So it was taken from the commanding officer of that particular unit, which conducted
Here it was taken.
Yes, yes.
That report is already there.
It's already there.
A favorable report.
Yes, it is a
So
favorable
we
report.
don't need to again reinstate it, because if we do it, you never know.
Yes, Lordship. Only the decision needs to be reconsidered.
See, I think paragraph 6, if we interfere with and direct them to look into in the angle of the judgment in that Rohit Chaturvedi, I think.
Very well, Lordship. Yes.
But if I ask them to look into further detailing and go into it, then your chance of that commanding officer may say something else.
Yes, very well, Lordship. Yes.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. B. Chakraborty appears on behalf of the.
1 to 4.
1 to
4.
4. Mr. H. Sharma appears on behalf of the respondent, learned additional senior government advocate appears for respondent number 5 to 7. The present petition has been filed assailing the order dated 28/10/2024, whereby the petitioner's remission application for premature release was rejected. Next. The brief facts which led to the filing of the present petition are that on account of commission of certain offences, or commission of offence,
He killed 3 of his fellow comrade lordship and injured 2 others. And he himself tried to commit suicide.
by the petitioner, which led to the death of 3 defense personnel,
Fellow Jawans lordship.
defense personnel, and grievous injury to 2 defense personnel, and commission of murder upon 3 defense personnel, and grievous injury to defense personnel, and also for trying to commit suicide. The Court of Inquiry, the summary general court martial found the petitioner guilty and sentenced him to suffer imprisonment for life.
Now, initially, it was a death sentence, lordship.
No. Didn't wait. Suffer imprisonment for life and to be dismissed from service. However, on the advice of the Deputy Judge, Advocate General of Northern Command to General Officer Commanding 27th Mountain Division, the case being rarest of rare case, court reassembled on 7th of July 2007, revision of the sentence. The earlier sentence was revoked and the petitioner was awarded death sentence subject to confirmation by the central government. However, the central government, after due consideration, commuted the sentence from to suffer death, inverted comma, to suffer death by being hanged by neck until he is dead, inverted comma close, to death of, inverted comma open, to be dismissed from service, inverted comma close, and to suffer, inverted comma open, and also, inverted comma open, to suffer imprisonment for life. Petitioner, in the meantime, already undergone actual imprisonment. As on the date of the order dated impugn order dated 28/10/2024. Have in the meantime had undergone actual imprisonment of 15 years, 4 months, 13 days bracket here as on 8/4/2024, 8/10/2024. And had also undergone a total sentence of 20 years, 1 month, 9 days, including remissions, bracket, as on 28/10/2024. The petitioner applied for premature release. By the impugn order, the application for premature release was rejected, taking into account the heinousness of the crime committed by the petitioner. It is under such circumstances the present writ petition has been filed. Upon filing of the present writ petition, a notice was issued by this court on 27/2/2026. The respondent numbers 1 to 4 had filed an affidavit in opposition, thereby supporting the impugned order dated 28/10/2024. In the said affidavit in opposition, it is mentioned that the order dated 28/10/2024 specifically takes into account the period of incarceration under by the petitioner, the remission earned by him, the nature and gravity of the offense committed, the circumstances surrounding the commission of the offense, the fact that the petitioner was initially awarded the sentence of death, subsequent commutation granted by the central government, the interest of the victims, larger societal interest in preserving deterrence, and the rule of law, and the necessity of maintaining discipline within the armed forces. In the backdrop of the above, the question arises as to whether the factors which were taken into consideration in passing the impugn order dated 28/10/2024 which led to the rejection of the petitioner's application seeking early release calls for interference. This court have heard the learned counsels appearing on behalf of the parties and have perused the materials on record. For perusal of the writ petition, it is apparent the contents of the writ petition. Apparent. That on 5th of June 2022, the Superintendent Central Jail Nagaon had submitted a report to the commanding officer as regards the conduct and character of the petitioner. And it was mentioned that during the period of his imprisonment, the petitioner was found to be satisfactory. It was also mentioned that the petitioner was allowed to avail 2 times leave, and each time he surrendered in due date without any adverse record against him. Petitioner's behavior and attitude towards the fellow inmates was found to be satisfactory. Further to that, his duties towards the welfare activities are recommendable, and for this special excellence, he was awarded with special remission from the Superintendent of Jail and Inspector of Jail, General of Prisons, Assam. Scientists have given a report on 25/5/2022. There was no complaint against him, against the petitioner. Petitioner actively participated in various educational and cultural activities of the central jail. And further to that, on clinical and mental status examination being carried out, the petitioner was found both physically and mentally fit for day-to-day activities. The commanding officer, who was under commanding officer, also submitted a report on 3rd of November 2022 on the character and conduct of the petitioner. It was mentioned in his report that taking into account the petitioner's old age mother, the recommendation of the Superintendent of Central Jail, Nagaon, petitioner can be the case of the petitioner can be processed for early release. In the backdrop of the above, if this court takes note of the impugned order, it is seen that in the impugned order dated 28/10/2024, authority, the authority, it emphasis on the heinousness of the crime. And further emphasize that any leniency shown to the petitioner by remitting the unexpired portion of the life imprisonment would send a wrong signal to the environment, and the same would be detrimental to the cause of maintenance of discipline in the army. In the backdrop of the above, if this court now considers the settled principles of law as to how applications for remissions are In the backdrop of the above, this court now finds it relevant to take note of the settled position of law as to how applications seeking premature release are required to be considered. In the case of Lakshman Naskar, bracket life convict versus State of West Bengal and another reported in 2007 SCC 626. Observed Supreme Court laid emphasis on which judgment they are referring to, Mr.
Lordship-
Counsel, paragraph
Lordship,
6.
There is a previous judgment of Lakshman Naskar, but that is a non-speaking
I
order.
refer to the judgment. I have referred to the judgment in the case of Lakshman Naskar versus Union of India reported in 2002 SCC 595.
Yes.
And mentioned and noted the guidelines so fixed to be taken into consideration when a convict can be prematurely released prematurely. In terms of the said guidelines, the relevant criteria where number one, whether the offense is an individual act of crime without affecting the society at large. Number two, whether there is any chance of future recurrence of committing crime. Number three, whether the convict has lost his potentiality in committing crime. Number four, whether there is any fruitful purpose of confining this convict anymore. And number five, socio-economic condition of the convict's family. The Supreme Court in the case of Lakshman Naskar Sutra, which was rendered on which was decided on 1st of September 2000. Further observed at paragraph number 8, as to how the guidelines which have been laid down in the earlier judgment in the case of Lakshman Naskar Supra are required to be analyzed by paragraph 8 of the said judgment being relevant is reproduced here in under. This court further finds it relevant to take note of another judgment of the Supreme Court in the case of Rajo, alias Ragwa, alias Rajendra Mandal versus State of Bihar and others, reported in 2023 SCC Online SC 1068. In the Supreme Court, upon taking into consideration that the state government in the said case did not properly apply the properly decide the issue pertaining to premature release of the convict, directed the remission board to reconsider by taking into factors laid down in Lakshman Noskar Supra. Paragraph 30 of the said judgment being relevant is reproduced hereunder. In a recent judgment delivered by the Supreme Court in the case of Rohit Chaturvedi, State of Uttarakhand and others reported in 2026 SCC Online SC 865, the Supreme Court categorically observed that the heinousness of a crime cannot be the sole factor to decide an application seeking premature release. Other necessary factors are required to be taken note of. It would include required to be taken note. The Supreme Court emphasized that there has to be a holistic assessment of the prisoner, and after balancing the societal interest with the prisoner's right to be considered for release on a fair and reasonable criteria. Paragraph number 7 and paragraph number 7 and 7.1 being relevant are reproduced hereunder. In view of the law laid down by the Supreme Court in the aforementioned judgments, and applying the same to the impugned order dated 28/10/2024, it would be seen that the sole basis on which the competent authority had passed the order, thereby rejecting the impugned order, thereby rejecting the petitioner's application, was taking into account the heinousness of the crime and without considering the various factors as to whether there is any chance of future recurrence of committing crime. Semicolon. Whether the convict has lost his potentiality in committing the crime. Semicolon. Whether there is any fruitful purpose of confining this convict anymore, as well as the societal economic condition of the convict's family. This court also finds it very pertinent to observe that in the case of Rohit Chaturvedi, the Supreme Court made it clear that our criminal justice system is based upon reformation, and therefore a criminal justice system that refuses to look beyond the gravity of the offense to the offender's transformation betray its reformative ideal, particularly at the remission stage. The Supreme Court categorically observed that justice does not permit permanent incarceration of an individual in the shadow of the worst act. Considering the above, it is therefore the opinion of this court that the impugned order dated 28/10/2024 is required to be reconsidered by the competent authority, keeping in mind the propositions of law laid down by the Supreme Court as referred to herein above. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. The competent authority is the respondent number.
Respondent number 1, Lordship, because the ministry has passed the order.
The respondent number one. One, na?
It's passed by the undersecretary, Lordship.
Huh? Number one, Leho. The impugned order dated 28/10/2024 is not in conformity with the law laid down by the Supreme Court. Number two. The respondent number one, 1, 2, and 3. We direct 1, 2, and 3, na?
Yes, Lordship.
The respondent numbers 1, 2, and 3 are directed to reconsider the petitioner's application for premature release by getting an up-to-date status. Because this was in 2024, no? Up-to-date status as regards the petitioner's character and conduct. And further to that, by taking into account the parameters so laid down by the Supreme Court in case of Lakshman Naskar Supra. The said exercise be carried out within a period of 3 months from the
Date of
3
receipt.
months.
From the date of receipt of,
Huh?
from the date of receipt of the certified copy.
Every 3 months. Full stop. Taking in number 3, taking into account that the petitioner is languishing in which jail?
Central Jail, Nagaon, Lordship.
Huh?
Nagaon, Central Jail, Nagaon.
Central Jail Naga. This court directs the registry of this High Court of this court to provide a copy, a true copy of this order to Mr. B. Chakraborty, so that the same may be duly communicated to the respondent numbers 1, 2, and 3.
Deeply obliged.
How many final disposals, sir? What happened that matter? I was thinking about it. There was one another matter now. That matter didn't come today.
No. My lord, connecting with this matter, my lord. No, my lord, it had not been tagged up. So, my lord, the speaking.
Don't worry,
my-
but
my-
I'll think this was that. But what happened to that matter?
That TB hospital.
No, not the TBS. This matter.
I can't.
These 3 matters, out of these 4 matters, these 19, 20, 21, 22, these are all similar matters.
My lord, my lord.
And these are PWD matters.
Yes, my lord,
What?
this one is, my lord, eviction, my lord.
This is eviction. The others are 19 to 22 is PWD.
PWD
That is
matter.
also eviction.
No, my lord, that is a contract. I am a contractor, my lord. I have been ousted
Different
and some
matters.
other person has been provided with the work orders.
So one at
My-
3. We have already crossed 1 hour.
My lord, my lord.
Okay, now let us see. Now, what is this case?
My lord, this case about, my lord, the eviction in the Sunitpur district, my lord, in the Chitolmari Chor. My lord, what has happened during pendency of this writ petition, my lord? Another petition had been filed challenging the speaking orders, my lord, and that has also been, my lord, not tagged today, my lord. So as both the matters are connected, my lord, may I pray, my lord, that this, both the matters can be tagged, my lord, on
This
Tuesday.
is for the solar.
No, my lord, the project had been, the eviction had been initiated for the purpose of, my lord, installation of a solar project, my lord.
And
And
stay.
no, no, my lord, what has happened in the meantime?
There's an interim order passed.
Yes, my lord, the interim,
Directed to cooperate with the respondent by submitting all relevant or in support of their claim and by appearing before the circular. Oh. And
my lord, my lordship has already considered this issue, my lord, once, and there is a detailed judgment had been delivered, my lord, and I have also made the part of that judgment, my lord, in this petition. It starts at, my lord, the page 74.
now, after this,
Mark.
there is a speaking orders.
My lord, after this, my lord, there are two sets of plots, one for the paddy field and one is the homestead land, my lord, wherein we are now residing. Now that homestead land had been earmarked and has been, my lord, taken over by the Assam Power Corporation Limited, my lord, for the purpose of installation. That gone, my lord. Now we are not possessing that land. Now the issue, my lord, concentrate only to the area wherein, my lord, we are residing as a homestead land, my lord. Only land left for our residence.
Now you are in the homestead land.
My lord, my lord.
Now, you just say that
Mal.
after this filing, you submitted documents. to
Yes,
the
yes, my
office.
documents. My
When you submitted the documents, they pass certain speaking.
speaking
orders.
order, my lord.
These speaking orders are challenged in another.
Another petition, my lord.
Have you received, got a stay there?
Yes, yes, my lord. Yes, my
Therefore,
lord.
this writ petition has become infructuous.
My lord, because this, yes, my lord, because this,
We have to consider the speaking orders.
yes, my lord.
So we close this as
Because, my lord,
infructuous,
in
it will
this
happen there.
petition, in
Huh?
this petition, my lord, basically we are, my lord, the prayer which we have made.
The judgment.
No, no, my lord, this is a interim order, my lord. It is fixed on 9th, my lord.
Same order, 16 pages.
My lord. My lord, enter facts have been narrated. my lord.
Brief chronology of the fact is that, my lord, they were in occupation of government land, my lord, which is reserved for construction, my lord, setting up and commissioning of the solar power project. Now, they, my lord, an exercise was undertaken, my lord, for evicting them from the government land. Admittedly, they are in occupation of government land. Now that is reserved for APDCL power project. They came before this honorable court. Matter came up before my lord, and my lord was pleased to pass an order, judgment and order, that is my lord 18/12/2024, whereby my lord has laid down certain parameters, that these parameters have to be followed in tandem with Salakuddin, that they will have to be given a right of hearing. Now, pursuant to my lord's order, exercise were undertaken by the district administration and speaking orders were passed. But those speaking orders were not in conformity to the parameters laid down by this honorable court, by my lord, in that judgment and order. So therefore, they again came before this honorable court. Those speaking orders were interfered with, and my lord, the district administration was directed by a coordinate bench of this honorable court that you start the process afresh and pass fresh speaking orders. Thereafter, notices were issued to them, asking them to give all the documents and testimonials. That is,
This is being challenged there.
yes, that notice has been challenged. The notice is dated 25/5/2026. Now, these notices have been challenged, saying that they already have given all the documents. They have so many ifs and buts. Now, during pendency of the writ petition, my lord, speaking orders came to be issued. And those speaking orders we have, my lord, incorporated.
Probably 2026.
Yeah. But those
Where there is a direction of maintenance of status.
yes, now this
Those
has
speaking orders have been passed. It remains here.
yes.
My lord, the notice which.
I didn't realize
No,
the
notice has now become redundant.
Already
My lord,
challenged.
my lord.
This has become
Yes, yes.
infructuous.
Notice has not
Because the
now become
basic,
redundant.
basic prayer is, my lord, to set aside the notices, my lord. Now, as the notice is merged with the, my lord,
Nothing, speaking
speaking
orders,
orders,
nothing remains.
my lord.
Nothing remains.
Heard Mr. A.R. Bhuyan, the learned senior counsel, assisted by so-and-so appearing on behalf of the commissioners. Mr. R. Bapujari, the learned counsel, appears on behalf of the
Revenue Department, my lord, respondent number
The revenue as well as the district administration.
district administration, I appear, yes, ma'am.
The present writ petition as is filed challenging the various notices which have been issued to the petitioners pursuant to directions passed by this court. The various notices issued dated 25/5/2026
My lord.
enclosed as Annexus 6 to the writ petition pursuant to directions passed by this court on where the direction?
Yes. That direction, my lord. It is, my lord, order dated 12/3/2025,
The 12/3/2025.
passed by this honorable court in WPC 1083 of 2025.
The said notices have not been stayed by this court.
Yes.
There were directions issued to the petitioners to submit the necessary documents
Yes.
and cooperate with the respondent authorities. However, it is also relevant to mention that till the returnable date, there was a direction that the petitioner shall not be evicted from the dwelling houses on the basis of the said notices. In the meantime, during the pendency of the instant writ petition, the petitioners have duly submitted their documents and submitted claims before the respondent, before the circle officer, the casually revenue circle. In pursuance thereto, speaking orders have been passed against the petitioners. And these speaking orders have been put to challenge by filing a writ petition by the petitioners, being WPC number 4114/2026. It is relevant to take note of that the learned coordinate bench of this court, while issuing notice directed maintenance of the status quo. Notice issued or not?
Yes, notice is issued, my lord.
Sure.
Yes, yes.
No, nowadays you never know what is.
Paragraph.
Have directed maintenance of the status quo. As in respect to the areas of land concerning the 77 numbers of petitioners
Yes.
therein. Taking into account the above, as the said notices have been already acted upon, and thereupon speaking orders are passed, which is the subject matter of challenge in another writ petition, nothing survives in the present proceedings. Accordingly, the writ petition stands closed. However, keeping the issues which are raised in the instant writ petition open to be challenged by the petition to be open, stands closed without prejudice to the rights of the petitioner. in WPC number 4114/2026.
my lord.
Interim order stands with it. I kept that, otherwise tomorrow a question arise.
My
So
lord,
I
my lord.
kept
The-
without prejudicing.
Yes,
your
yes,
case.
my lord.
Absolutely. And so
Yes, now what do you have to do with PWD?
My lord, the PWD, my lord, what has happened, my lord, I was engaged, my lord. I will say the word engagement, my lord. My lord, he is a contractor, basing on which, my lord, he had been allotted with the preliminary work order, my lord, with a, my lord, condition that, my lord, if my lord, just for a moment, my lord, take up one matter, my lord. Uh, Page 27, my lord, of WPC, my lord, first one, I'm referring, my lord, 3947.
You were petitioner claims to have been issued certain preliminary work orders
My lord.
for maintenance of bungalows and so and so.
Exactly, my lord.
Petitioner claims to have been allowed to continue, but the administrative approval for the said work had not come in, apprehending that could be some other areas where petitions have been filed. Meaning,
My lord, this work order will be issued on receipt of the administrative approval from the government, and necessary formalities such as signing of tender agreement will be observed accordingly. Now, my lord, on the strength of this, I had been allowed to carry out my works, this maintenance and other works which I am assigned. Now, my lord, while I was continuing till date, my lord, till the filing of the writ petition, my lord, they have not come up with this formal administrative approval and the other requirement which they have, my lord, incorporated in their official letter dated 29/3/2025. Now, my lord, from the, when we, my lord, come up before my lordships, my lordships protected us with an status quo order, my lord, as regards the work orders. Then, my lord, when the affidavit had been filed, my lord, I have come to know, my lord, that a fresh tender process has been, my lord,
so
said-
thereupon you started your work.
My lord, yes, my lord. Yes, they have admitted, my lord.
And
Then, my lord, I have started my work, and if my lord just take up the affidavit in opposition in one matter, my lord, in from paragraph, from page number, my lord, 50. 3947.
let us take first one, huh?
Yes, yes, 3947. My lord, my lord, I am referring to page 56, annexure A, my lord. Advance signing.
56. Completion certificate.
My lord, this is a completion certificate of my assigned work, my lord, modification and upgradation of works, office chamber, so and so, so and so. The BBD department, first floor, Janata Bhavan, so and so, my lord, and this is the present bill value, 41,95,106. Part, my lord, they have issued this completion certificate. However, my lord, this completion certificate had not been, my lord, as I have taken the instruction, is not available with the petitioner, my lord, till date.
They are on record.
It is on record, my lord. Admittedly,
do
they
they
have
say?
not denied, my lord. I am also not disputing, my lord. I am also
What
not.
do you want?
Now, my lord, I want that, my lord, suddenly, my lord, without this administrative approval or the allowing me to continue, go ahead with the work, come up with a fresh tender, my lord. They have. But this tender, how they have issued, my lord, where they have notified, I could not find out from the, my lord, the annexures which they have annexed. It just for a moment, my lord, my lordships may be pleased to take up page 62, my lord, annexure C. Page 62, my lord. Now, my lord, this is a letter which says from to the executive engineer issued by the chief engineer regarding the annual maintenance works for the capital complex comprising Janata Bhavan and the minister's colony. With reference to the subject cited above and in continuation of this letter under reference, you are hereby allowed to initiate the tendering
Now,
process.
what is your period of your earlier?
My lord, my period, if I go by the, my lord, this initial letter, my lord, it is says that the, my lord, your tender for the above mentioned work has been selected for acceptance at your own.
Your date of completion is 6 months.
6 months, my lord. So
that 6 months is long over.
no, that 6 months is, my lord, already gone, but I have been allowed to proceed, my lord, further. That
is illegal.
No, my lord, because the tender which they have now floated, my lord.
The tender is from 1/8.
My lord.
Tender is from 1/8. So
My lord.
that tender has no relevance with this because of the fact that you The fact that have you received that money or not?
No, no, no. Money has not been, money has not
they
been
have to
paid.
pay.
My lord, may I clarify in this regard? Lordship is taking up WPC, my lord, 3947, page 27.
27.
3947.
Lordship is
27, my lord. It was for a period of, my lord, 6 months. For this period, my lord, he has completed.
Understood.
For that, my lord, he will be, of course, he will be entitled, even though there is no administrative approval, we'll have to have it. But, my lord, to allow him to continue after the expiry of this period, my lord, that, my lord, he has no right. Secondly, my lord, in the affidavit,
And the affidavit has been filed by the chief engineer. So the moment the completion certificate has been
no,
given.
this is not the completion certificate of this particular work. But he has alleged that in the why we have annexed it, that let me explain it, my lord. We have annexed this particular completion certificates to demonstrate before the honorable court that, my lord, a gate pass was issued to some of the employees of the petitioner so that they can carry out the, my lord, cleaning work in the secretariat as well as the ML hostel. For those work, my lord, this has been issued. That particular gate pass for this particular works. These are not the works which are questioned before the honorable court, which are, my lord, in adjudication before the honorable.
Why did you enclose?
Just to show that because he was continuing with this particular works, that gate pass was issued. That will not, my lord, entitle the petitioner to continue, my lord, for more than 6 months pursuant to the work order at pay scale. Yes. Only for that part, not for this.
No, my lord, I am also not on that I should be allowed to continue. My lord,
That Mr. Bhuya is reasonable enough to understand.
Yes. My lord.
I'm not on that. My question is, as of now, you don't have the administrative approval for that earlier period.
Not, my lord, we will have to, my lord.
But so without getting that administrative approval, the problem, you would never get the money.
But that's why we will have to work it out because we have.
Therefore, we keep the matter pending.
My lord.
We can't dispose it of. We have to keep it pending so that we've now passed the orders that where is the administrative approval.
Exactly.
The fact that he did the work during this period, there is no denial.
My lord, I cannot continue beyond the period.
As regards the fresh tender, you can participate.
But my lord, one thing I want to submit, my lord, the tender in what mode they have notified, in what manner, my lord, I do not know, my lord, what has happened. When I filed this writ petition, my lord, then suddenly these work orders, according to the petitioner, has been issued in back dates, my lord. If my lord call for the records, my lord, then it will be revealed.
No. At the end of the day,
my lord,
the fact remains that you were given for a period of 6 months.
6 months.
You have done it, you should get the money for
Yes,
whatever.
yes.
First of all, these 6 months, where is the completion certificate?
That, my lord, we'll have to verify because, yes, that will place everything. In that point, my lord, we have.
Secondly, we require the administrative approval.
My lord.
Otherwise, you won't get the money.
No.
So administrative approval as well as the completion certificate let them
Certificate,
produce
yes,
for the works for these. As regards for other periods, you can go ahead. There's no, and petitioner can participate.
My lord. But my lord, that opportunity had not been provided, my lord. The
No,
tender.
It will not be provided specially to the petitioner.
No.
Floated.
For all,
May
my lord.
participate
For
now.
all,
We have
my lord.
already work order issued, my lord.
My lord,
pursuant to
now
tender. We
in
have stated
what
in the
mode,
affidavit.
in where they have
Work order
notified.
has been issued for this
somebody
financial year.
else.
Because
Somebody
his
else, my
work was over in, my lord, September 2025, my lord.
No, my
So
lord.
status quo, my lord, will not be effective. It will be effective till that.
No, my lord,
He was not there.
I am with all respect to my learned additional advocate general, which he is submitting, my lord. My respectful submission before my lord is that notice inviting tender, at least my lord, people should know that such a tender has been floated. Now, in what mode, in what manner they have notified, that is not available on record, my lord. Only a letter, my lord.
E-tender.
It was the tender, I suppose. Yes.
The procedure, my lord. If we go by the letter, my lord.
If it is more than 20 lakhs, it has to be.
My lord.
Unless
below 20 lakhs.
Huh?
But even then, I can place that, man.
Yes,
Though
yes.
it is not on the challenge before the honorable court, that we can place.
It's okay. My question is here. Heard Mr. A.R. Bhuya, the learned counsel appearing, senior counsel assisted by so-and-so appearing on behalf of the petitioner. The learned additional advocate general, who is also the standing counsel of the PWD. The petitioner no, from the affidavit which has been filed by the chief engineer, PWD, it is apparent that the petitioner carried out works for a period of 6 months. As preliminary work orders were issued, subject to issuance of the administrative approval. The affidavit so filed by the chief engineer is incomplete on the aspect as to whether during the period when the petitioner was issued the preliminary work order which the petitioner admittedly carried out, there were, as on date, the administrative approval has been provided. Inasmuch as without the administrative approval, there cannot be a financial sanction. Further to that, there is nothing brought on record as regards the completion certificate, as regards the completion of the certificate, any certificate evidencing completion of the work during the period wherein the petitioner was issued the preliminary works. Detailed affidavit in that regard be filed by the PWD through the chief engineer. So, taking into account that the same may require some time, list this matters on 4th of November 2026. Let them come up with this.
But there is a status quo order that may kindly continue.
The status quo cannot.
Mal. Earlier it was continued, my lord. Oblige me.
This court duly, this court further takes note of that in the meantime, further takes note of that the petitioner's preliminary work orders were for a period of 6 months. And the same elapsed sometime in the month of March 2026. Under such circumstances, the question of passing any status quo or continuation of the interim order by this court dated 3/8/2026 in the facts of the case would not be justified. Accordingly, the interim order which was passed on 3/8/2024 is not continued.
Oblige me, deeply obliged.
You get it?
My lord.
Mr. Bhuya has been very out there to say that he requires this and that. That you get that.
My lord,
but
as
be
the
more
instruction
reasonable
have
enough.
received, my lord. Because these people are knows, my lord, what is happening in the department, these contractors, my lord. When I come before my lord, then everything happens, my lord, so hurriedly, my lord. Oblige, my lord, deeply obliged.
Other cases are different.
No, same issue, same cases. It is. Work
Only-
orders are different.
Work orders are different.
Yes,
Oblige.
one matter, yes, Mr. Kotoki, no matter what was that? No matter was there, na, that matter pertaining to requisition. Let's take up that matter. Madam, your matter, all the MAC appeals, we will take it up on one by one on every Monday, Wednesday and Thursday, Friday at 2 p.m.
My lord, and item number 12, my lord.
What 12? MAC?
Yes, my lord.
What is that?
The improvement
What is
petition.
12?
My lord, my name has been reflected, but I have given headed of the brief.
What?
Yes, my lord.
What are you doing with 12?
That's an improvement petition, my lord. The one of,
12 is no hearing.
yes, there's an IA also, IA for improvement. It's an IA. My lord, I had filed an IA, but I have not, I don't more hold the brief anymore, my lord.
So you have to give notice.
I have already
and
given NOC. I've already given my NOC.
No, notice to the party as per High Court Rule 60.
It's okay. Get a date.
No issue, like.
On one matter, and two, I can finish it up. These MSc approval.
So ours will be on next Wednesday.
No, there are 4 appeals. 30 of you is amongst yourself. Take whichever date you on these appeals.
Okay.
I'll take Friday.
Whichever it is, you can.
Oblige.
I'll take. Yes, Mr. At that day, Mr. Kotoki, I raised this issue. On the other hand, content that there are various procedural safeguards provided under Act of Bihar thereby. Your case out here is, this is not a case whereby you could have initiated the proceedings under Section 3. It could have been done under the 2013 Act. That is one.
Because of section 3 provide, my lord, they can acquire land for the, or they can requisition the land for the company if the company is formed for the purpose of rehabilitation and resettlement. Because it is they requisition the land for the APDCL. APDCL is not a company formed for rehabilitation and therefore section 3 and the invoking of section 3 my lord, without jurisdiction. Apart from that, my lord, they in their affidavit they have categorically stated they have selected this land for the purpose of acquisition of land. When your decision to acquire the land, can they bypass the 2013 Act?
আমার কি করে land, some land. Because Mr. Kotoki, you are right on this. I have been always thinking on this. Because there are two aspects which the government has been carrying on. By virtue of the Assam Land and Requisition and Acquisition. One is, this act has been used indiscriminately for everything. Secondly, another matter which I took up, I don't know where the matter has gone, where Mr. D. Nath is appearing, is nearby the airport.
Airport. No.
Whereby they have again done the same thing, requisition and then acquisition. And the submission which is being made in that case is, look here, we are doing the requisition to look into it whether these lands are necessary. But for that, you don't require a requisition because the mandate otherwise is there in section 11. Or if we go by this section 3, requisition cannot be for that purpose.
The purpose of requisition act is different, my lord.
Now, you see, power to take possession, where any state has requisition under section 3, the state government or area may, by order, direct the owner of the tenant or any to be who is in possession of the land, whether the time of requisition or at any time thereafter, for the land, whether at the time of requisition or any time thereafter, before the land is requisitioned for requisition or under intent to surrender possession. Against the intent and condition that so and so. Yes. Any land has been requisitioned under section 3, the state government may use or deal with it in such manner as may appear it to be expedient and may require such land by has published again land and tell me, Mr. Borbujari, see, Section 4 or Section 11, Section 4 of the 1894 Act or Section 11 provides scope of survey.
Yes. Yes.
But in this case, requisition is there. Then take over the possession under 4. And then 5, repairs of the building. Now 6 says that the lands which have been requisitioned, in possession taken, it will be acquired by a notification issued in the official gazette. Now, section 9, let us look into 9. Notwithstanding anything contained herein before, if in the opinion of the state government or the collector it is necessary or expedient to acquire speedily any land for works or other development measures in connection with flood control
Yes.
and anti-erosion measures, including embankment drainage, or for the construction of border so-and-so, 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 the state government on order in writing acquire the land, stating the area and the boundary. Collector shall cause the order passed on the subsection to be served in such manner as may be prescribed of the land, and also on the tenant or the occupant in case where the owner is possession of the land. The same effect, taking the claims to compensation for all interest in the land may or within him, by may be made to him within such time may be prescribed. Where the person to be so served is not readily traceable or demand, the collector shall cause the above order and notice to be published in a manner as may be prescribed. Then order of acquisition is served or published, and 2, the land shall stand absolutely in the state government free from all encumbrances on the date of the order is published. Collector may at any time after the land becomes so vested proceed to take possession thereof. On such vesting, the order passed by the year shall be published in the official gazette in the manner prescribed. Compensation is 11. Let's see the prescription. What is the prescription? An order in a year shall be in form of section and notice on the year shall be demand. The publication of 9(1) or the notice as required by the proviso to so shall be made, affixing a copy each of the order and notice in form respectively in some suspicious part of the land. Under 9(1) of the Act as required by section 10(3) shall be in a manner of service given. Case of an order in order 29(2). Section 50.
1 5.
1.5. So by this you can do it. Then why do you need the requisition?
Requisition because here, if we go by the regular process of acquisition, then that is my lord, publication of a gazette notification under section 6. The condition precedent will be, my lord, first to requisition the land.
209.
My lord,
Because it is the same parameters.
no, first of
Same parameters applied for 9 and 6 is same.
so same parameters applied for 9, but if we go for straight acquisition, immediate acquisition under section 9, then the purpose of requisition is purpose to acquire land is very limited. If we first of all requisition,
But we have included everything.
no, we here section 9, kindly see, my lord.
Yeah.
Section 9 for a moment, lordship. Kindly see section 9, my lord. I'm getting it. Yes. Section 9, speedy acquisition of land in certain cases, notwithstanding anything contained herein before. If in the opinion of the state government or it is necessary or expedient to acquire speedily any land for works or other development measures in connection with flood control and anti-erosion measures, including embankment and drainage, or for the construction of border fencing and allied works, including border roads and checkposts connected with so-and-so the state government. So the purposes for which
Now, as per 3, what you
now 3, my lord, the scope is broadened up. 3 says,
enough.
yes, if in the opinion of the state government,
Obtaining supplies and services essential to the life of the
life and so, or for providing proper facilities for accommodation, transport, communication, irrigation, flood control, anti-erosion measures, including embankment and drainage, or for providing land individually or in groups to landless, flood affected so-and-so, or to a society registered under the Assam Cooperative or a company incorporated formed from the benefit of landless from so-and-so displaced person, and for purpose of construction of border fencing allied works, including border roads. It is, my lord, akin to section 9, the latter part of the provisions of section 3. Here is a case, my lord, where we come within the ambit of maintaining supplies and services essential to the life of the community. Now, electricity generation and distribution of electricity is an essential service. Now, here in this case, my lord, only an affidavit, short affidavit, has been filed on behalf of the district administration. It does not disclose the total facts, only the statements, a short, very short affidavit without annexing the relevant materials. In the meantime, having, my lord, and this matter was conducted by learned additional AG, my lord, B. Gosabi. Now this has been entrusted to me, considering the gravity of the matter in view of my lord's order dated 3rd of August 2026, because my lord has now evolved a broader issue, whether in case of acquisition, in view of existence of the 2013 Act, can we resort to partly under 1964, then partly under 2013? Can we mix up both these cases? This is a pure question of law. So therefore, at this stage, if I may most humbly and respectfully pray, your lordship may be pleased to accommodate me for some time. I will come up 2 affidavits, my lord. I have received the detailed instructions. There are 2 matters, my lord, 2 connected matters, items 16 and 17. In both the matters, my lord, I will be filing affidavits, my lord, on behalf of the district administration, bringing on record the total exercise that was undertaken in terms of, my lord, the 1964 Act. And my instruction says, my lord, that award has also been passed by now. Award has also been passed, and the quantum of money for compensation that has been deposited in the civil deposit. All this, it is kept as a civil deposit, because they have refused to accept, my lord, receive the compensation amount. So everything I have, these two
have you issued notices to them?
Yes, yes. All the provisions of 1964 Act have been scrupulously complied with, right from issuance of, my lord, notices under Form A, B, C, D, my lord, under section 3, then taking over possession, then my lord 5, and then finally 6, gazette notification, and then which has culminated into passing of an award. So award has also been passed. But since Lordship has posed a broader question as to how, if at all, can we mix this? So an affidavit from the Revenue Department, I have already communicated to the Revenue Department. I have received some instructions, my lord, from the Revenue Department to answer my lord's query as to whether we can mix up these two acts. Because my instructions from the department, my lord, categorically says, my lord, that this 1964 act can be, my lord, very well resorted to. Now, only the question, my lord, so far as my lord, assessing the quantum of compensation, we are taking the aid of 2013 Act. And to that extent, there is a notification of 2015. That although
Mr. Kotogi, you look into this judgment, let us see the 9 judges judgment. See the concept of eminent domain, which was there, on the basis of which all these judgments, 64 Act and all these things were made, were based that ever doctrine of eminent domain is there, they can do whatever they require. Your land, whatever may be, will pay compensation if everything is open. But the 9 judges bench, 9 or 7 judges, 7 judges, find that, see, these are acts done on the basis of Article 39. The effect that these articles are such that we, for the greater good of the society, this is the basis. But the Supreme Court later on said that you cannot, on the basis of that, now, things have changed. There were 2 judgments of Justice Krishna, which was there, and that was referred to the larger bench. Larger bench said that no, that the doctrine of eminent domain is not there. So therefore, you have the concept of 2013, that if 80% of the people
Agreed.
agree,
You can
then there is question of area. Because you see, at the end of the day, merely because of the fact that the government wants to take it, it cannot. So whether this act can be said to be in conformity with that judgment.
The 64 Act. That's us have to look into it.
Because you see, what the state is doing is they are
No,
indiscriminately
there
using.
I no doubt I am not on that, my lord. The state action the purpose object of the state action is I am not disputing it. It is a public service.
No, therefore my question is, this 64 Act came at a time when after the World War II, there was a requirement of
Requirement of that.
acquisition.
Similarly, my lord, 68 Requisition and Control of Motor Vehicle Act.
Yes, all these things.
All
These came after the World War II.
Two.
Where it was necessary that for the state to take over. Here you have 64, Nagaland you have 65, all these places you have these type of. Now, these acts were then held by because similar action happened out there in the case of Bombay and all these places where certain areas the government took over. And Justice Krishna said that it was for the greater good. And as such, in view of Article 39, it can be taken because the public interest is more important to the effect. But that law has changed. In 2000, recently, by I think this judgment was given by Justice Diva Chandrasud, wherein he categorically said that no, that principle of eminent domain is not there. If the principle of eminent domain is not there, after that judgment, what are the curbs which are there, the 7 judges bench? We may have to look into it because now you enter anything by way of an amendment to this act and do whatever you feel like. Means no person tomorrow, your land out there, the government, the government which has a majority tomorrow say that I don't like Mr. Kotoki out there. He has been troubling the government, so we do one thing, we take away his land by requisition. Can be done. We require it. How do you do it? You can't justify, you can't challenge that. So therefore, this is a very important aspect which needs to be looked at because we are now in a developing world. Yes, some concurrence, something to that effect. Yes, earlier 1964 Act, how it was different. Now what has happened is different. Now they have increased the scope of 74 Act by bringing company everything. Earlier, if you see the 1894 Act, company was out.
Out, my lord. Now they are bringing it.
Here the company was not there. The company, because this was required at that point of time only for taking into account after the World War II, what was the requirement, and people were going into a socialistic point of view. In fact, that 7 judges bench judgment came because of, in Bombay, there was a huge mall. Some builder had purchased a plot of land, real estate had purchased a plot of land. Government said they will take it over. Can you do that? This is how the 7 judges went. Can it be said to be greater good on the basis of that? Can you take over? Because the right under 300A is also there. Because this is directive principles. We'll hear on that. Interesting.
Lordship, may be pleased to allow me to file, my lord, an additional affidavit, my lord. Because
Mr. Agabudari appearing on behalf of the both the district administration as well as the revenue department submits that a more detailed affidavit would be required in the present proceedings from the revenue department as well as from the district administration.
District administration.
The above list this matter again on how much time?
If Lordship may be pleased to accommodate me for 3 weeks, my lord, 3 or 4 weeks, my lord.
29th of September 2026. In the meantime, the affidavit be filed on or before 24th of September.
Yes,
29th, on 24th of September 2026. Same orders passed earlier shall continue in the next.
I'm so obliged.
You look into that judgment.
My lord, sure.
My lord.